Okay, let's see if we can get the computers up.
Okay.
Okay, we got just a second to go. Okay, good morning, everyone. Today is Tuesday, March 24th, 2026. It is now 10 a.m. We're here for the regular session of the Hunt County Commissioners Court. At this time, I'll call the meeting to order. And again, I will announce if anyone's here for the RV park zoning out by Bowles Home, we will not be talking or discussing that today. The developer has pulled it at this time and asked us not to hear it today, so there'll be no discussion on that. And when we get to the public speaking, any of you are welcome to speak at that point in time, or you can wait till the item on the agenda comes up and you'll have an opportunity to speak at that time. So it's y'all's choice. I will allow it either way. And so anybody needs to leave and wants to speak first, that's fine. If everybody wants to wait, that's fine. Okay? At this time, I'd like to have a moment of silence for our county attorney that passed away Monday night. And we lost Bill Dukes this week, which is a pastor at one of the local churches and been real active in the community in various organizations. And Smith Gilly passed away, I believe, Saturday. And not only was he active in the community, he served 3 terms, I think, at the state representatives for our area. So he was very much a pillar of our community. And we just need to keep their families in our thoughts and prayers. So at this time, we'll stand, have a moment of silence. I'll lead in a prayer and then followed by the Pledge of Allegiance. Our Heavenly Father, we come to you today with grieving hearts. We ask you to bless all the families that have lost their loved ones. Lord, we recognize we've got holes in our community now that'll have to be filled. But it's nothing like the families and their losses to their family. And we just ask you to be with them, comfort them, only as you can, and lead them through this darkness of time. And Lord, we also ask you to continue to bless our county and our state and our country, and especially all our soldiers in harm's way. And Lord, we just ask you to continue all of your blessings to us and ask you to give this court wisdom today to make the decisions that are proper in your eyes. In Christ's name we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Thank you, everyone. This morning we have Commissioner Money, Monroe, Smith, and Harrison present. I'm Judge Stovall presiding over the meeting today. Commissioners, we have the minutes from March 10th, 2026 regular session. Entertain a motion for approval.
Make a motion for approval.
So moved.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. This time we'll have public testimony. Speakers are limited to 3 minutes and should conduct themselves in a civil manner. The Commissioners Court cannot take action on items not listed on the agenda in accordance with the Texas Open Meetings Act. Concerns will be addressed by county staff, They may be placed on a future agenda or addressed by some other course of response. Again, any of you that filled out the paper and you would rather speak during a different time, you're welcome to do that, or you can speak now if you choose. Gary Marshall. Okay. Is that Carl Crowley? Is Carl? I think he's also on the other, yeah. June Ridgway. Okay. Okay. Pam Sorrow.
Good morning, Commissioners. I appreciate all the work that all of you do. You have a difficult job. I would love to be here today to speak only about codes, permits, and zoning vulnerabilities, and insufficient funding, and the insufficient infrastructure, and the complexities of coordination between Hunt and Collin counties, which has not yet occurred regarding the meadow, and the fact that no formal assessment has been made of the cost and rate of road deterioration, and multitude of questions around the new emergency services district that's going to be in Collin, that because the property's on county line will need to be coordinated with. However, I also want to inform you of the properties remaining next to the meadow, the owners that hunt and fish and want to live in peace and have ponds. And if you look at the map that looks like a teardrop, the wastewater treatment plant is going to have effluent that's going to destroy the neighbor's pond where he fishes. And I also want to share with you that there are complexities you're going to have to deal with. For example, you've seen the Ken Paxton information. I'm not going to go there. However, there are other issues that they posted an 8.5 by 11 piece of paper in a field just this week, which they're calling a public notice for a bond hearing. And the attorney that signed that is not their attorney because Paxton shut down the meeting. So their current attorney didn't post that. So it's like whack-a-mole with deficiencies and violations that are very concerning. Also, the issue of the fact that there are funding mechanisms that I'd like for you to research, because you have a nonprofit with elder members forming lots of LLCs, and then saying in writing, which I have documents of, that the money is going to go back to nonprofit. That is against some statutes and limitations based on my understanding of current laws and rules. And so there are multiple issues also with Fair Housing Act, because they don't structure their developments like you and I are used to with real estate. They form their agreements like an investment agreement, almost like buying a third of a racehorse, in my opinion. And so some of the laws are not like you and I are used to seeing. We need your role, in my opinion, is to follow the U.S. Constitution, the Texas Constitution, and all you have to do is remember the number 4. That's all you have to remember. Article 4, Section 4 of the U.S. Constitution says we will be protected against invasion. And my family came here in the 1600s. We certainly love religious freedom, but the culture is not allowing assimilation or peacefulness, and I'm very concerned about multiple aspects, and hope you will take this into consideration as you make your decisions to protect our values, because Audie Murphy was born in Hunt County. The first church was in 1852 here in Hunt County, and I want you to remember that as you make your decisions as well. I know you have a difficult decision, but Broken Arrow has said no, Alabama has said no, Kaufman just yesterday said no, and I hope you'll say no. Thank you very much.
Thank you. Scott Finney. Did I say that right? Okay.
I'd like to wait until item 23 is brought up. So
Okay, no problem. Victor Gore.
I'd like to wait till item 5 is brought up, action item.
Okay. David White. I see him back there hiding. He's always got something to say.
I thought I better get this out before my knees gave out. So, thank you, Your Honor,
You can
Commissioners.
come sit in this chair.
Oh, no. Oh, no. I don't want that chair. It's good to see you all. Appreciate the opportunity to speak. I know some people will be upset that I don't have a general quote, but I do have a quote from Scripture. Romans 12 talks about, if at all possible, as much as it depends on you, live peaceably with all. So that is my life's desire, and here today as I speak, it's my desire. So I want to speak on two topics. Most of you guys know I'm a pastor. Probably most of you don't know that I was an engineer. I'm sorry. No ill offense against engineers. But it's been a while since I've used a Bernoulli equation to solve any kind of fluid dynamics question or designed any microcircuit that is as small as a hair. And, I know some heads have thicker hair and some heads have thin hair and some heads have no hair.
Easy now.
And no offense, Your Honor, no offense.
Easy.
But I say all that to say that, I just kind of did a little research into this data center because, I've probably been a part of designing things like that in the past. And I don't know that most people realize the amount of resources that are required. Wow, that was a quick 3 minutes.
I'll give you a little bit more. Oh, it's not you? Okay.
Just the amount of electricity that's required. Juice produces only about 6% of what they actually sell. The rest of it is purchased and resold. As far as water concerns, I don't know, the average 100 megawatt data center is going to draw about 528,000 gallons per day. So a 432 megawatts up to about 2.2 million gallons of water a day. It's a huge drain, okay? Don't get me wrong, I love technology. I've worked in it for years. Like I said, I'm an engineer. My concern is not with the technology. My concern is with for-profit companies who want to drain the resources of our local community with little to no cost on their part. I think Commissioner Smith sent out something on Facebook talking about that. And my concern was, well, why aren't we considering having them be self-sufficient? If they want to develop this for-profit business, then they should be developing the infrastructure to support those standalone systems. I know a lot of people have talked about that. I just wanted to get those facts out there to talk about just the massive amount of resources that are required for these data centers, okay? The other topic I want to just touch on briefly, the lady before me mentioned, as a pastor and as a Christian, it's my responsibility to point out things that are false in other beliefs, and in particular, the belief of Islam. Okay? Well, now my 3 minutes is up.
Wrap it real quick.
I'm going to close. It is not a religion of peace. In fact, it's not even a religion. It's an ideology that wants to dominate all other religions. Thank you.
Thank you, Mark. Krista Shield.
Thank you, Commissioners Court. I'm Krista Shield, and I represent the RARE Foundation. I'm the Texas Director for RARE Foundation that's actually been the catalyst for opening the lawsuits and the criminal investigations against Epic City, now rebranded The Meadow. The 1991 explanatory memorandum from the Muslim Brotherhood's Goal Plans for America, it exposed the fact that Double R Mud and Epic City, now rebranded The Meadow, is a civilization jihadist process, and it's with a handshake and a smile and a lot of lies. We've caught them in their lies. It's a deception campaign until the Muslim population grows to the point of violent jihad. All you need to do is look at the 1400-year historical history and look at Europe today, the UK, and now Canada, falling at just a 10% population, which we're quickly approaching and even at in cities here in Texas. We have actually found Sami Hamdi and Marwan Maroof, who were Hamas kingpins operating out of these very mosques like East Plano Islamic Center that are involved in these developments in order to create the Mecca of the West right here in Northeast Texas between Collin and Hunt counties. And Kristi Noem found our evidence so compelling that she arrested both of these men and deported them. I've been to this meeting for Double R Mud in a field in 90-degree heat with a public notice that was on an 8x11 sheet of paper and a clear plastic sheet tacked to a board 400 feet off of the road. And we were told at that meeting that we were trespassing in order to read the public notice. There is a precedence where countries that were once Christian, Buddhist, Hindu, today they are Islamic totalitarian regimes. The Constitution does not cover for conquest. And I submit to you as somebody who has spoken this and inserted my investigative findings on the congressional record that wherever Islam grows, freedom dies. You must deny these developments. Thank you.
Thank you. Carol Davis.
Hello, Commissioners and the public. I'm Carol Davis, and much of my career was in the environmental field, working for a regulatory agency. And I understand that you do have limitations here in Texas about development in unincorporated areas. But in particular, I was involved with air quality planning. In fact, I was the first air quality planner for the largest county in the contiguous United States. And I'm concerned also about the fact that this should have been anticipated as being a hotly interested item on the agenda. Yet the paper only 2 days ago came out with information, as far as I know, about Core Scientific. And it's interesting, their editorial says that the public needs to provide input. It's absolutely essential. But how can we, when this is put on the agenda quickly and the paper reports the presentation will be on Wednesday, when in fact on today's agenda, there's supposed to be a presentation on one of your action items. And more importantly, I guess I'm concerned about the Open Meetings Act provisions of the state law as how it's being carried out here in Hunt County. I think there should have been enough notice, maybe even noticing the people in the area of precinct or Commissioner District 3 and the county at large because of the massive potential water usage. You know, there's a big lawsuit going on in East Texas for an individual, I believe it's Ed Bass, wanting to drill very deeply into the perhaps aquifer. This location has not even been put in the agenda where this Core Scientific is. And from what I understand, it might be in the Cache area, not far from Tawakoni. We get our whole county gets water from Tawakoni and from wells. And so I'm also concerned about the potential aspects of pollution. And I would urge an environmental assessment be encouraged to be completed, but especially I'm concerned about the discussion of regulations in the closed session that you're going to have today. You referenced the two provisions in the government code, and I'm not sure that I would agree that that shouldn't have been discussed in an open meeting. And I would advise next time you have a meeting where you can have enough public get seats, because many people are out in the hallway and they can't possibly maybe hear well. So in conclusion, I will be filing an Open Records Act to get information and may even be contesting the closed meeting session. And I guess, is that the 3-minute bell?
Just wrap it up for us.
Okay, well, that's my concern, and I'll be back. Do you have any idea of how long the presentation will be today?
I think 15, 20 minutes.
Okay, thank you very much.
All right, anyone else? state your name and address, please?
Good morning, Commissioners and Judge. My name is Dianera Ayala. My address is 1590 County Road 3523. I'm coming in regards to the community of 2101 against the RV park. We would like to thank you so much for letting us know that it was pulled off the agenda today. But the community did want to speak up and just say, whenever it does come back, we'll be back. And we did want to let you know that at the Lake Tawakoni Committee, the Lake Tawakoni Zoning Committee, there was a big crowd, and we all did oppose to it, but we just did want to let you know in regards to that. Thank you. Have a wonderful day.
You too. Thank you.
Judge, I did have, this morning I've received 11 emails associated with that. In lieu of the fact that it's been removed from the agenda, do I need to submit those as public comments for you? Okay, I will turn those in for today.
And then we'll put those on the record for the meeting.
All right, thank you.
Okay. Anybody else?
I've got several online comments.
Okay.
All right, these are, I have
You
several
got 3
online-
minutes, by the way.
I was actually about to mention that because a few of them are relatively long, and so I'll be timed as well, but all of these will go onto the record like they normally do. The first one is from Laura Thomas. As a lifelong Greenville resident, I have very grave concerns in regards to the new AI data center being built on the south side just outside of Greenville. It's my understanding that these centers provide a great drain on the electric and water resources in a community and not much benefit, if any. This is not a wealthy community with unlimited resources, and I'm afraid that the results would put a strain on city residents who are already struggling financially with the burden of everyday living costs. Please do not allow this without investigating how these massive centers affect the people who have to live next to them. Next comment is from Paula Morgan, who's a woman veteran and Army aviation veteran. Dear Hunt County, Texas Commissioners, I wish to express my concern regarding the potential pending approval of the development of the Meadows Plat for Hunt County, Texas. I confirm that this is an extension of the Epic City, a Muslim community underway in Collin County, Texas. As the veteran has stood with her brothers and sisters in arms, traveled overseas to other countries to witness firsthand the devastation of their way of life, it is vitally important to understand the risks involved and the threats they pose to Americans. We've seen Sharia law ruin Europe and American cities in Michigan and Minnesota, among others, where we've allowed their way of life to flourish. Individuals involved in this project have already exhibited shady behavior by holding private meetings, reportedly changing board members in the middle of a field. Some quick noted facts of interest regarding their economic challenges include, according to a 2024 report by Global Financial Magazine, Iraq has the most Islamic banks with 15, followed by Bahrain and Qatar with 7 and 5. Sudan and Saudi Arabia's Islamic financial institutions held most of the assets at $484 billion and $322.2 billion, respectively. Iran is currently at odds with the United States and simply cannot be trusted. They have ulterior motives which would be foolish to ignore. Additionally, the state of Texas has brought a lawsuit against our county. We are obligated to adhere to the ruling of the state of Texas in the absence of a home ruling. Thank you for your considerations and allowing the public comment on this matter. The next comment is from Dana Marshall. Gary and Dana Marshall provides their address. Opposition to zoning request. Dear Commissioner Smith, we're writing to formally express our strong opposition to the proposed zoning change for approximately 4.53 acres located at 7895 FM 2101 in Quinlan, Texas, from E2 Estate District to C2 Light Commercial District for the development of an RV park. Our family, along with many of our neighbors, chose to live in this area based on the reasonable expectation that it would remain quiet, stable, and low-density residential community. The introduction of a commercial use, particularly an RV park, would fundamentally alter the character of our neighborhood in ways that are inconsistent with its current zoning and established use. An RV park would inevitably bring increased traffic, placing additional strain on local roads and raising legitimate safety concerns for residents. In addition, The transient nature of RV park occupancy could result in higher population turnover, increased noise level, and activity at all hours, all of which are incompatible with the peaceful residential environment we currently enjoy. We are also concerned about the broader economic and community impacts. Unlike the permanent residents, transient occupants of RV parks may not contribute to the community in the same way as long-term homeowners, particularly in terms of sustained property tax support, civil engagement, and investment in local schools and services. This imbalance raises questions about whether the proposed use would fairly support the infrastructure and community resources it would rely upon. Finally, we're deeply concerned about the long-term implications of this zoning change. Approval of the commercial zoning in this predominantly residential area could set a precedent for further non-residential development, gradually eroding the integrity, cohesion, and intended purposes of the community. Such changes may negatively impact property values and diminish the quality of life for current residents. For these reasons, we respectfully urge you to deny the zoning change request and uphold the residential character of this area. We appreciate your time and consideration of our concerns and respectfully request to be notified of any upcoming hearings or opportunities for public comment regarding this matter. Sincerely, Gary and Dana Marshall. The next comment is from Pamela Jones. Good morning. I'm not a resident of Hunt County, although I do work and shop in Greenville and live within walking distance of the Collin County-Hunt County line. I found out late last night that there's a County Commissioners Court meeting today at 10 a.m. I'm not able to attend due to work commitments. Please consider this email when making your decision on the Meadows. I'm against the current development request for the Meadows for several reasons. Several residents in Collin County filed a request for a hearing with the TCEQ back in 2025, and as of yet, a hearing has not been held. Below are just some of the reasons I'm against development of the Meadows. Reason 1, traffic hazards. Due to current city and mud housing and population growth, the roads are already congested with the current construction. Approximately 10,000 homes are approved to be built in current muds and the city within a 1.5-mile radius. September 11th, 2023, Josephine City Council voted to contest a similar mud, the Golden Barn mud, on the grounds that the city is not able to provide water at this time, and the city did not have capacity to provide sewer. Water won't be available until 2028. Roads per Hunt County Thoroughfare Plan will not be ready for 20 years, as they are long-term projects. I would be highly appreciative if the TCEQ plan would not be ready for 20 years, as they are long-term projects. It would be highly appreciated if TCEQ would take into consideration that the same set of circumstances for water and sewer exist for any muds that are proposed on County Road 695 or in the Josephine and surrounding areas. The area that's been proposed for the County Line Municipal District of Collin County and Hunt County CL Mud is on County Road 695. I use 695 to drive on to cut through to avoid the traffic congestion in town due to developments. Additionally, there are TxDOT and/or Collin County and making various road improvements in the area of Josephine, Texas. The community school and new housing on FM 547 towards Farmersville, which creates time delays. County Road 695 is a time saver for me. I can avoid the drivers who have no respect for the driving rules. This is a no-brainer given the accidents and deaths on our highways. Citizens have died in this area recently. Accidents on FM 6, FM 1777, and County Road 1148 come to mind. As for Collin County, where CR 695 is, I could not find any reference in Collin County Thoroughfare Plan or the NTCOG plan for improvements to County Road 695, where the County Line Municipal Utility District is to be located. Both Collin and Hunt counties approve very small lots and homes. Example being Magnolia 10 plat, approved by Hunt County before they requested to come into the ETJ. Elevon near Levon in Collin County appears to have even smaller lots and houses. All right, there's 3 more pages of that one, but I'll put that in the record with the rest of these. All right, the next comment is from Susan Partridge Metz. My name is Susan Partridge Metz, and I'm a resident of Precinct 1 at 5438 Silkstocking in Farmersville, Texas. I'm writing you today to formally oppose the proposed data center development in our community due to significant risk in our long-term water security, the safety of our community, and our quality of life. As documented in the 2021 Region D Water Plan, Hunt County faces serious unmet water needs through the year 2070. Under the county's 2020 subdivision and land development regulations, it's the responsibility of the Commissioners Court to ensure that new developments do not jeopardize the necessary services for the supply of water for existing residents. A high-consumption industrial facility like a data center threatens the reliability of our water supply and our local agricultural economy. Furthermore, I'm deeply concerned about the emergency response capacity for such a facility. Data centers utilize massive battery energy storage systems. According to Texas State Fire Marshal guidelines and NFPA 855 standards, these systems pose unique risks, including thermal runaway and the release of toxic gases. Our local volunteer fire departments are not currently equipped or trained to handle industrial incidents of this magnitude. Noise mitigation and quality of life. Additionally, I'm concerned about the 24/7 low-frequency noise generated by cooling fans and HVAC systems. This constant tonal hum often bypasses standard noise ordinances, but causes significant sleep disruption and health issues for nearby residents. We must ensure that any facility is required to perform an ambient baseline study and install mandatory acoustic baffles or sound dampening barriers to protect the peace of our neighborhood. I urge the court to advocate for the following requirements before any plat is approved. Time is of the essence. Sustainability study. Demand an engineering report for any facility exceeding a daily water demand of 20,000 gallons. Drainage and runoff, Section 4 and ESM. While the site may not be in a designated floodplain, the massive impervious cover, concrete and paving, required for a 285 megawatt campus will drastically alter the natural drainage. Per the engineering standards manual, the developer must prove that runoff will not negatively impact downstream properties or county infrastructure. We demand a full drainage study be filed before any plat approval. Water availability verification. Require a will serve letter from the water provider that accounts for sustainable supply through 2070 per the Region D Water Plan, including on-site storage for fire safety and hazard mitigation. Require a formal fire safety inspection report and hazard mitigation analysis approved by the Hunt County Fire Marshal. There's a little bit more to that one, and I'll put that in the record as well. The next one is from William A. Dykes. Inquiry about Wolf Creek MMD and Crescent Meadows development. Commissioners, I am William A. Dykes, residing at 4035 FM 118 in Greenville, Texas. I'm reaching out to request further information regarding the Wolf Creek MMD and Crescent Meadows development projects. Additionally, I'd like to express my opinion that Hunt County does not have a need for an AI data center. In my view, the concept of AI leans more toward being artificial than truly intelligent. Thank you for your attention to this matter. That's the end of the public comments.
Daniel,
Yes.
we're hearing two different stories today, and I want to make sure the public understands. We're saying one place we got a zoning issue, and we're saying the other we can't stop it because of zoning. So, correct me if I'm wrong, I think I'm right on all this. In 1980s, the state legislature granted zoning authority to Hunt County and Cook County, I think it is, for Lake Ray Roberts, I believe it's up there, and for Tawakoni, to within 5,000 feet of their take lines for their lakes, because they were being developed in a fast and haphazard area. So the state did give us that authority within 5,000 feet of Lake Tawakoni take lines. The rest of the county, we have no authority over zoning. We can't stop anybody from coming to do whatever they want to on the land. We've asked for it. I think all our counties have been asking for it. We've not been able to get the state to grant us that permission or that authority to better regulate the growth of our counties. And so we continue to ask them, and hopefully someday we can get some results. Is that all correct, Daniel? Do you, best of your
Yes,
knowledge?
that's all
Yeah.
correct. The other things that are on the agenda are not zoning related.
Yeah.
They are related to the county's other authority. Under the local government code, there's a chapter 232 that guides and limits counties' approaches to subdivision authority, but subdivision regulation and zoning regulation are two completely different things.
Okay. All right, anybody else? Nothing else to read? Okay. Being none, I'll close the public testimony. Daniel, you still need action item 1 under old business?
Yes.
Okay. Under old business, A, action items, number 1, a public hearing to discuss and take action on resolution / order revising Hunt County subdivision regulations, engineering standards, plat application procedures, and other related regulations regarding 1, homeowners association, property owners association, real estate trust, or other bodies or boards restricting or limited property uses. 2, restrictive covenants, conditions, subsequent reversionary interest, or similar property restrictions running with the land. Daniel.
Okay, this was discussed at the last meeting. There was the first part of a public hearing. After I'm done talking, there will need to be a public hearing open for that again before any action is taken to approve or to not approve the changes to the subdivision requirements. What you got in front of you is about 7 or 8 total pages of changes. Most of these are very technical because once you change one part of the subdivision regulation document, it has effects on many other parts. But overall, what this does is 5 different categories of things. Number 1, it adds requirements that certain documents that restrict property transfers, like HOA requirements and restrictive covenants that run with the land, which means they apply to everybody for all of time in most cases, that those be filed as part of the platting process. The idea here is to give the county the authority to disapprove any of those plats that come in with restrictive covenants or other HOA requirements that are facially illegal under the law. And so if they prevent transfer based on race or religion or sex or anything else, with a very narrow set of exceptions for communities specifically built for older people, that those could be rejected or disapproved is the current language in the statute based on the facial illegality of those documents. I don't expect that that's going to be a long review if any of those come in because they're either going to be facially illegal or they're not. And there's only a few things in state and federal law that are facially illegal. Number 2, the way that this is rewritten requires those documents to be filed at certain times during the process. Number 3, it requires that plat amendments go through the full plat amendment process if those documents are going to be added later. And so if a community was developed and before they sold any lots, they wanted to add restrictive covenants or new HOA requirements that would prevent the sale of the property to certain races, they would need to come back through the replatting process or the plat amendment process, which requires notice to people in a certain distance and publication in the newspaper. And if it was something like that, that's so obviously illegal, like preventing the sale to other races of people, then the county would have an opportunity to deny approval of that or to disapprove. Number 4, it clearly defines which developments are subject to these rules, which are developments that file their plat application after the date that this is approved. Number 5, it would disallow plats that do not follow the process or invalidate restrictions that are not timely filed. And so if there's a plat that's filed after the date that this is approved, if it's approved, and a developer tries to sell properties with a restrictive covenant, but doesn't come back through the plat amendment process, then they would have a basis based on the county's rules to ask a court to invalidate the impact of those rules. And so I know it's a long document. I can go over any of the sections that you may have questions on. I know last time around, a couple of weeks ago, I sent out a kind of a plain language summary, which unfortunately was longer than the document itself, but it goes over, what each section does, why that matters, and then the key points of the document itself. And so I can answer any questions that you've got about any of the specific language or the reasons for any of the sections that are proposed to be changed here.
Okay, Commissioners, you got any questions before we have our public hearing?
Just one, last time we had some comments, and one of them was concerns about delay in the process. You made reference that the things that would be of issue here should not be delayed. Could you elaborate on that a little bit?
Yes, starting 3 sessions ago, the legislature started changing the rules that apply to county approval of plats. And there's a lot of different rules that are applicable to that, but most of them are contained within a specific chapter of the local government code, which is chapter 232. That's where the common wording of that, or the common reference to that, is the 30-day shot clock. The 30-day shot clock is a few years old now. It's been tightened up and changed in both legislative sessions since it came into law. But that provides a very specific and very short time frame for any county to consider whether or not to approve or disapprove of any plat that comes before the court. None of these rules would extend that time period at all. It is outside of the county's authority to even try to extend that time period. If the county doesn't follow the 30-day shot clock, and there's an item, the Meadows deal that's at the end of the agenda, is one of those items that's currently under the 30-day shot clock. We're 26 days into the 30-day shot clock. And the impact of that and the other rules, there's some rules that require a 10-day review. There's some that require a 15-day review. But for an initial plat, it cannot extend the time period because it's not allowed to. The only way that it could potentially extend the time period is if in the first 10 days after filing, the county sends out a notice of deficiency saying that you didn't provide all the documents that are necessary. And then that puts a pause on the 30-day shot clock until the application is resubmitted with the appropriate documents, or at least until it's supplemented with those documents. But from a time frame perspective, this does not change any of the timing rules. The county will still be subject to the exact same timing rules that are in Chapter 232.
Anything else?
On this is with the limited that we are, what we can and can't control on subdivisions, regulations, different things. All this is just another tool, if you will, in the toolbox to help protect future homeowners on undeveloped land, right?
That's correct. There's been a lot of litigation lately, especially over the past 10 years, related to restrictive HOA requirements and restrictive covenants that are part of the deed to transfer the property that are either illegal on their face or are written in a way that's difficult or impossible to understand. What this requires is upfront transfer of those documents to the county for any plat application that comes after the date of adoption. And allows the county basically to see whether or not there's any illegality there. What it won't allow is protection of future homeowners by the county parsing through and trying to make legal determinations based on what may be vague language. The homeowner's still going to be subject to kind of a buyer beware policy that's throughout state law on what those restrictions say. And sometimes the homeowners don't know that until they're trying to sell their house. and a title company won't insure that sale, or will insure it, but with a exception or exemption for that section because it's not clear. Some of those have come up recently where there's restrictions on certain farm animals, and the state has passed the Right to Farm Act and some other acts that allow farming despite what restrictive covenants say. And so those are some of the things that we would look at to determine whether or not it's facially compliant with state law, whether or not it violates any of the recent pro-property owner changes in state law, or is just otherwise facially illegal on its face, like it's a violation of the fair housing laws because it restricts sales to certain races or religions or sexes. But yes, I mean, the idea overall is to protect future homeowners by making sure that illegal restrictive covenants or HOA requirements are caught right up front at the initial platting phase.
Anything else? Okay, at this time, I'll open it up to public testimony. Anyone who wishes to speak for or against this item can come forward and speak. Could they hear me outside? Or is anybody else out behind y'all?
It's delayed and it's very quiet, and they can't hear you real well out there.
Okay. Being none, I'll close the public hearing. Commissioners, what's your pleasure?
I'll make a motion to approve.
Second.
Got a motion and a second. Any other discussion? All in favor say aye.
Aye.
All opposed?
No.
Motion carries 1%. Okay, under new business, the consent calendar. Entertain a motion for approval of the consent calendar.
So moved.
Second.
Got a motion and a second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item B, approval of accounts payable.
Motion to approve payables.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Approval of line item transfers.
Motion to approve line item transfers.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Approval of budget amendments.
Motion to approve budget amendment.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Approval of payroll and personnel.
Motion to approve payroll and personnel.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 1, a proclamation for fentanyl poisoning and awareness on April 14th, 2026. Misty, is Misty here? I didn't see Misty. Misty Little out there. She knows? Okay. Misty Little is the one requesting this. She's created this nonprofit to make the public aware. She lost her daughter to fentanyl in 2021, I think April 14th, 2021. So the court has participated and helped with that organization from a public perspective. And so I'll read the proclamation. Whereas Cheyenne Little's life was tragically taken April 14th, 2021. Her death is the first publicly acknowledged fentanyl poisoning death in Hunt County. Whereas in order to honor their daughter's legacy, Cheyenne's family has created weare3fp.org. Fiercely fighting fentanyl poisoning to bring awareness to the deadly effects of fentanyl. Whereas opening the eyes of our community to this deadly drug may prevent one death, in hopes of keeping parents and loved ones from experiencing the same grief and pain. Cheyenne's death will not be in vain. Now, therefore, I, Bobby W. Stovall, County Judge, Hunt County, do hereby proclaim the day of April 14th as don't shy away. It's not a little problem. Fentanyl Poisoning Awareness Day. We encourage all citizens to help spread the message for fentanyl poisoning is coming to after our children. And it is up to us to do our due diligence to expose its lethal dangers. Commissioners, entertain a motion for approval.
So moved.
Second.
Got a motion and a second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 2, a proclamation for Development Disabilities Awareness Month, March 2026. Mary, yeah, I saw Mary. Good morning.
Also National Ag Day, and so our 4-H kids, we had our county council meeting, and they made everybody some refrigerator pickles.
All right.
Bringing you a little love.
I'd rather you brought me a cow or something.
Thank you, Mary.
Oh, we're in.
I'm going to say, you knew this was a good day to do this. The length of the court today, we're going to need a snack. So.
Yes, I'll get you a little sustenance. Well, good morning. Not used to quite the crowd, but hello, everyone. I'm Mary Shockley with the Hunt County AgriLife Extension Office, and I just want to say thank you to the judge and commissioners for your continuous support. And today we're here to talk about Developmental Disability Awareness Month, so we're very excited for this proclamation. I reached out to Miss Sharon over there at the Daisy Day Center, and she's going to give her little presentation after mine, but as y'all know, I work with many different audiences within AgriLife, and I most recently had the privilege of working with Bland High School's life skills class. Their master teacher reached out to me and wanted to teach them a vocational skills, and so we got them food handlers certified, and I just wrapped up that program, so we're going to click through here, and I'll tell you just a little bit about it. So what we did was me and Miss Davis made a partnership, and we met last semester, and we decided we were going to get these 5 high school students food handlers certified to hopefully give them some vocational skills past graduation. 3 of the 5 students are seniors, and so they will be entering life after high school in May. And so me and Miss Davis and Miss Day, we made a great partnership with each other. I adapted the state certification course. AgriLife Extension hadn't had an adapted course like this before, so I took the typical standard certification and I broke it down and made it their own. And we had multiple hands-on lessons and lots of great experiences. I will say Bland High School, I'm going to give them a quick shout out because the principal, the cafeteria staff, Miss Davis and Miss Day, and the custodial staff wrapped their arms around these 5 children to get the certification. And we got to go into the cafeteria and poke around, and it was a really beautiful thing. So we'll go to the next slide. So what it looked like was a typical 2-hour course. I broke it down into 10 lessons covering these 5 units of foodborne illnesses and TCS foods, food safety and personal hygiene, storing food safely, and preparing and serving food safely, and clean facilities. So again, I took a standard 2-hour course and broke it down into 10, and it's been really hard to leave this group because we became a little family. And since I started working with them and the cafeteria staff, every Friday this group comes in and now washes the breakfast dishes and kind of has practical application weekly since we've had this training. So it's been pretty special. Okay, I think there's 1 or 2 more. What we gained, well, I gained perspective and met a whole new group in Hunt County that I had not worked with before, and they deeply touched me. And I feel like we empowered them with the vocational skill. We had a 100% passing rate. Every one of them got 100%. They gained independence and self-efficacy. We learned about adaptability and collaborating with each other, and we're going to have a big celebratory field trip to the Hugs Cafe in McKinney and Greenhouse that their whole mission is to serve this audience and give them employment past high school. So we're going to go meet them. And so that's me. I just dipped into this audience. So I reached out to Sharon because this is her world every day. So Sharon, will you come up here? Okay, come on in.
Hi, my name is Sharon Ori. I own Daisy Dayhab on FM 1903 in the Cache area. And Mary had reached out to me, and I didn't expect so many people, and I'm not a good public speaker, so I apologize.
You're doing great.
Thank you. But people don't really, unless you know somebody with developmental disabilities, people often don't realize just how much they're capable of. There's a guy out there in the lobby that it was so crowded I didn't try and bring him in again, but he is both deaf and blind. And he is one of the hardest working volunteers that I've ever met. We have volunteered at Fish Ministries to pack the meals for at-risk kids. They're easy to open, easy to prepare meals that we deliver typically 2 days a week, pretty much a full Dayhab day. We deliver them to all the public schools in Greenville and throughout Hunt County and even some schools in Collin County. We go out to Merritt, we go to Farmersville, we go to Caddo Mills, we go to Quinlan, and that might be everything, and then Greenville, but Greenville is all the public schools. Yeah, hang on, I made notes because I don't know what I'm doing. But Michael helps with that. We typically don't pack the bags, but when it's the beginning of the month and they don't have bags packed and we need to pack them because there's nothing for us to deliver, then we'll go ahead and pack them. And with some of them, I have to check the bags. Michael, the deaf-blind guy, his bags are perfect. Even if I've got a video on our Facebook page. He had dropped something. It fell into the next container. He picked up what he needed and put it in the bag, then found the one that had fallen into the wrong spot and put it in the right spot. And I'm going, dude. And it's kind of embarrassing to say this considering my business and the people that I work with. I don't speak sign language. And so I can gesture things to him, and he pretty much understands what to do. His caregiver, occasionally I'll shoot her a text and I'll say, hey, we're at Walmart, and I don't know what he's saying, and I'll, send her a video of him, and then she'll tell me, or I'll say, hey, I want to tell Michael this. Can you send me a video? And she'll send me a video, and I do it, and he understands, and it works out great. But that's just some of the things that they do. They volunteer at Home for Angels Animal Rescue on FM 36 in Caddo Mills, if y'all are familiar with that. But a lot of their animals comes from either drug houses that have been shut down or pet shops that have been shut down. And so the animals have not been taken care of properly. A lot of them have, they were malnourished and people didn't know how to care for them. And she takes these animals in and does amazing things with their rehabilitation. And we go out there and we, first they cleaned, the cages, or what's the word? Environments? Yeah, it's not really cages because they're bigger than habitats. They clean their habitats and the enrichment toys, and then they'll clean the building, and then we help feed the animals, and then they get to help socialize the animals and get them acclimated to being handled and stuff. It's a lot of fun, and they love it. Spring has just started, and so we'll be starting in a couple of weeks our volunteer work at Community Garden at Home for Christ Community Church. It used to be Aldersgate, but this is our third spring that we'll be going out there helping out in the garden one morning a week until it gets too hot for us to do that anymore. We attend Golden K meetings until we have so many schools to deliver that we don't have time to go to the meetings anymore. They volunteer at Halloween on the Square, passing out candy to all the kids. Our very first year we went out there, we ran out of candy 5 minutes before it ended. We lasted longer than Walmart. When I looked up at Walmart, I didn't even see them leave. They had packed up and moved out. And so, but that was our first time, and more than half of everybody was already gone by the time we ran out of candy, but it broke my heart for those kids in the last 5 minutes. So we've made sure the next 2 years, because we just started doing all this once we finally got a van, but we've made sure we've never run out of candy again, and the following 2 years, we're calling people over to us saying, hey, we've still got candy, and passing candy out to people as we go down the street, because my guys aren't going to leave anybody behind. They attended Officer Cooper Dawson's funeral in Rockwall. We got a group together and we went and paid our respects, because several of our guys have taken Greenville Citizens Police Academy and Citizens Fire Academy. So we've got a really good relationship with both the police department and the fire department, and we've been recognized by the chief of police for our involvement in that. We help at L3. We pick up, they accumulate gifts for individuals that live in group homes and nursing homes at the holidays. And we go out there and we load up the gifts in the van and we go and deliver them to the group, well, not to the group homes, but like to the day hab for the delivery at the group home. We ring the bell for the Salvation Army, except this year we went out there and the Salvation Army never showed up with a bell and a bucket. But she said that won't happen again next year. But we've done that. We volunteer at the Christmas lights at the sports park. They're a very active group of people. And then, we do a lot of fun stuff. We get season passes and go to, one group goes to Hawaiian Falls, one group likes to stay closer and go to Splash Kingdom. We go camping. We've been on Route 66. We went to New Orleans last year. We're going to San Antonio this year. I mean, they're an incredible group of people. And like I said, until you know somebody with developmental disabilities, people often see their disability. They're really capable of so much more than people give them credit for, and we just want them to be recognized in the community for what they're able to do. Thank you.
Thank you. Thank God for people like you.
It's just the way the good Lord made me. People tell me that on a regular basis, and I'm like, I get paid to hang out with my friends. Like, y'all are sitting in offices doing paperwork, and I'm going shopping, I'm having parties, we get DJ Cajun out there. It's amazing. It's amazing.
That's certainly a better deal than I got. So.
Thank you.
All right. Mary, you want to read the proclamation, or you want me to?
I would love for you to.
Okay. 2026 Developmental Disabilities Awareness Month. Today is estimated that over 600,000 individuals in Texas have developmental disabilities. These individuals aspire to the very same hopes and dreams we all cherish as Texans, including self-sufficiency, finding full-time work, practicing one's faith, and making a difference. People with developmental disabilities have unique skills and perspectives, but they also face unique challenges. Throughout our history, these Texans have made the Lone Star State a better place for all of us. Texas is better off with all citizens, when all citizens can flourish. So we must commit ourselves to do everything possible to facilitate personal and professional success for people with developmental disabilities. When these students are included in the classroom setting outside of special education, they are more likely to achieve their full academic potential. By the same token, when people with disabilities are included in the workforce, they have an opportunity to earn a competitive wage, work as a valued team member, and support our state's unrivaled economy. Our state and nation thrive when inclusion becomes the norm. Each year, the month of March is set aside to raise awareness about developmental disabilities and to show solidarity with affected individuals, their families, and their care providers, as we emphasize the importance of inclusion in every aspect of life. During this observance and hereafter, Texans can learn about how classrooms, workplaces, houses of worship in the communities are stronger when they include people of all abilities. At this time, I encourage my fellow Texans to raise awareness about developmental disabilities and continue to work toward full inclusion and equality for all. Therefore, I, Bobby Stovall, Hunt County Judge, do hereby proclaim March 26, 2026 to be Developmental Disabilities Awareness Month. Again, thank y'all very much, and if you're ever low on energy, don't be around her, because she'll run you into the ground.
Thank y'all so much.
Thank you.
Thank you, Mary.
All right, Commissioner, I entertain a motion for approval.
Motion to approve.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 3, proclamation for Child Abuse Prevention and Awareness Month for April 2026. Commissioners, I entertain a motion to approve this.
So move.
Second.
Got a motion and second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 4, the Treasury's monthly report for January 2026. Brittany,
Good morning.
good morning.
All right, in your package, you will have the treasurer's report for month-end January 31st, 2026. We had a month-end balance of invested funds and cash in bank of $70,569,299.57. All bank reconciliations were balanced, and the auditors and the treasurer's books agree. In the month of December, we had, at the very end of the month, we had our big tax push, and all of that money you'll see on the transfer in and out investment on that second page. You'll see we invested about $15 million in the month of January. We took all that money that we got in December, and those investment rates were holding about 3.7, 3.8% in the month of January. Any questions?
Commissioners? Thank you, Brittany. Entertain a motion for approval.
So moved.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 5, a presentation by Core Scientific on planned data center development in Hunt County.
Hi, everyone. Thank you for having me here today. I appreciate the commissioners and Judge Stovall giving me the opportunity to come in and talk about our project. Before I introduce myself, I just want to say this will be the first of many public meetings we have. We'd like to have some town hall sessions and provide the opportunity for community members and citizens to come in and learn more about the project and ask us questions. So my name is Carol Haynes. I'm the Senior Vice President of Power and Policy for Core Scientific. What that basically means is I have responsibility for our utility relationships and contracts and working with the utility partners to make sure they can serve our needs in a meaningful way and in a way that's responsible. I also have responsibility for our site location and selection, so where we locate our projects. And I've got responsibility for all of our local affairs, which includes tax incentive work, which I will talk about today, as well as state affairs and our federal affairs. So we look at that as a holistic way to make sure that every community that we locate in has a very close relationship with us from the start of a project to make sure that we're meeting community needs as well as our business needs. A high-level overview of our project. So this is a graphic of our project site along with where it's related in existence or where it is in relation to the county roads. We are located roughly 7 miles south of I-30 and about 2 miles east of Cache. So in a relatively rural area. There are some existing substations in that area, and I'll show another picture on the next page. The tract of land, which is where the Core Scientific logo is represented there, is next to an existing substation that's owned by Rayburn and Farmers. And that sits within the Lone Oak School District. The site is set back from existing neighborhoods and primarily has open land around it. That land, that's a zoomed-in picture of the property. It is about 70 acres for that particular property. You can see it wraps around the existing battery storage facility that's out there, as well as the Encore and Rayburn substations and facilities. The power is designed for approximately 285 megawatts of compute capacity for a long-term facility. The project does have ERCOT interconnection, allowing us to start taking power in 2027. That interconnection was worked on and approved in 2024. And I can talk a little bit about what other approvals we've gotten from regulatory as well as the utilities here and what studies have been done. And then I know there were a lot of comments and questions related to water. We have had early conversations with Cache Special Utility District to ensure that we will plan our water usage responsibly. Most importantly, this type of a facility that uses new technology for cooling uses significantly less water than what is generally people expect it to use. So our daily average use is equivalent to a super Walmart. The majority of the daily use of this facility will be for restrooms, coffee makers, kitchens, things like that for the employees themselves. And we have the ability to use new technology, which includes closed loop chiller systems that are non-evaporative, and so they're filled once, and that's all the cooling that's needed for that facility. And I'll talk a little bit more about that in a moment here. This is just an image of our facility that we do have that's operational in Denton, Texas, so just north of Dallas. This is just intended, we've gotten some questions about what our facilities will look like here. Well, we don't have a full design plan because we're very early in the stage of planning for this project. I thought it would at least be helpful to show what our data center facility looks like that's in Denton and give everyone an idea of how that might look here. So I guess this is getting into some of the comments that we've heard or that I hear about some of our other locations as well. And the goal that I have is to provide some accurate information about what our project specifically will be. So I know one of the things that we hear is just communities trying to understand what the value will be to the community. We will bring high-paying jobs to the community. We will work with local technical colleges, high schools, and other key stakeholders in the region to make sure that we can hire locally, and we will make sure that the tax base that we bring stays here. So we're not looking for tax abatements for local or anything like that. We want those dollars to stay in the community and help support growth within the community for schools and other services. With regard to water, as I mentioned earlier, the new cooling technology that exists for data centers is much less consuming. It consumes 95 to 100% less than old technology, and it really is related to the non-evaporative closed loop chiller systems that are brought in and can fuel the entire network and system. And even when it comes to filling those systems for the first time, we have the ability to truck water in from another region and fill the technology with that. In terms of some of the other questions related to power bills, I didn't hear as many of those comments or questions today, but it's easier for me to talk about this early. We will fund 100% of our data center needs, including any infrastructure that is required to support our project. So we've already funded $33 million of electrical infrastructure through the utility here that will support everything that they will build in support of this project. Those facilities that they build will also provide grid stability and stability for the community at large, but we will fund 100% of that. And as I mentioned earlier, ERCOT and the utility companies did in fact complete grid reliability studies to make sure that when this project were to go into service, that there would be reliability for all the citizens and businesses in the community. And those studies were completed in 2024. One of the other questions we get is about whether or not these facilities are loud. The sound level at the perimeter of our data center is expected to be equivalent to decibel levels around a soft whisper or a conversation. And I have another slide that talks about the OSHA standards on different decibel levels and can provide a more detailed explanation on that. And then the last comment here is related to AI and just the needs for AI, and I'll talk about that as well. But I do believe AI is a global race and that it's very important for the United States to remain ahead of the technology and the use of AI in our military defense systems, in our businesses, and in governmental defense. And I'll talk a little more about that. On the sound level here, so this is a chart from OSHA, where it's the Health and Safety Administration from the federal government, where they look at typical sound levels, and they think of that in relation to safety standards inside or outside of facilities. So our typical facility, the perimeter of our facility, will be somewhere between 40 and 60 decibels. Again, this is an OSHA chart just talking about at 40 decibels, that would be considered a soft whisper from 5 feet away, and at 60 decibels, it would be equivalent to a standard conversation. When we come to some of the town hall meetings and other things, we can provide additional information and answer questions related to that. We've also looked at it in relation to where the project will sit. We know the nearest existing house is at County Road 35 and another property that's nearby, and we're confident that the decibel levels will be at or below those numbers. How the project will benefit Hunt County. First and foremost, as I mentioned, related to taxes, we do not intend to seek tax abatements. So all the taxes related to our project will stay here. We already are aware from site visits and being out and looking at the site that there's probability that road upgrades will be needed. We want to make sure that we come into the community and are adding value to the community and making it better and are being good corporate citizens. And we will look at road upgrades related to construction traffic and making sure that the roads continue to be good for everyone in the region, school drivers, local traffic, all of those kinds of things. When it comes to traffic on the roads and labor, we will have likely 200 construction jobs at any given time throughout the course of the project and development of the project, which is probably 18 to 24 months. We will have 800 total construction jobs for the project, but we expect about 200 contractors on the site at any given time. We will do everything that we can to hire that from local labor and local trades in the surrounding area. We recognize that we may not be able to get 300 electricians from within the county, but we'll do everything that we can to hire people locally. And in terms of full-time employees, the expectation is that we will have approximately 150 full-time permanent employees that will be skilled jobs. At any given time, there will probably be 35 to 50 employees per shift, just depending upon what their exact work function is. Those jobs will include everything from security professionals, data scientists that will actually be operating the compute equipment itself, facility operators that are making sure the building is operating as it needs to, the backup generators, the chillers, all those kinds of facility operations are working. Engineers that will also collaborate with the facility operators and work on the technology itself, and then the technicians that will be performing that work. Again, in all of our other facilities that we have, we develop job training programs with the help of local community members. And the goal there is to start within the high school and talk about what programs they have within the high school, and then talk with local colleges and technical colleges to find out how we can make sure that if people want to stay in the community and have jobs here, that this is an opportunity for them to be trained and work at our facility. And then the last piece is the total investment. This will be dialed in more as the project is more defined, but we do expect to have more than $4 billion investment in the county. That will come with a combination of property investment, the facilities themselves, the data center facilities themselves, all the infrastructure related to the facilities, the chillers that I've mentioned, backup generators, fire suppression equipment, all those kinds of things. And our goal is to work with the local businesses in the community here to make sure that we're being additive. One of my last comments here is just related to AI. I know this is one of the big questions that we get from policymakers and from citizens is just, why does AI infrastructure matter? And the reality is AI is happening in the world today, all throughout, different countries, including the United States. And for us to think about military defense systems and the fact that there are autonomous weapons and things of facial recognition and recognition for everything, even related to fire suppression and things like that, there's an incredible amount of value in all of that data being housed at data centers that sit inside the United States, whether it's for military defense, like I mentioned, or our businesses using it in terms of healthcare or healthcare records or records related to Bureau of Motor Vehicles, houses, property taxes, all of those kinds of things. It's incredibly important that that data sits inside the United States and is governed by U.S. laws and institutions here, which the federal and state governments are already actively looking at, rather than that information being needed for the United States to stay competitive in a global economy and keep us safe, but that data being housed at data centers that are in other countries like China, where they can take that information and use it for the government's advantage. Our current footprint, just to give a perspective, also something we get a lot of questions on. The majority of our facilities today are also in relatively rural communities. So we've got some combination, but we are in North Dakota, Oklahoma, North Carolina, Kentucky, Auburn, and Georgia, as well as we've got sites in Texas that I mentioned. The majority of our communities are rural and have been, we've got a track record of high-paying jobs where we do local training and we really immerse ourselves into the community. And I'm very hopeful that over the course of town hall meetings and the opportunity to be here and answer questions, that you can look at us as being a good citizen and adding value to the region. That's all of my prepared comments. I'm happy to take questions.
Commissioners?
Why do y'all go to rural areas? Why don't you go to cities?
The reality is that it's usually where we go to where the utilities tell us they'd like us to go. So as we do our site selection process, we look to where the electric utilities tell us they've got power and available grid infrastructure. Usually that's a lot harder to find in a large city.
What do you use to cool? Glycol?
It's a combination, and we do have an engineer here who is much more technologically advanced than I am, related to cooling, but it's a combination of glycol and water.
Okay.
In a closed loop system, like I said, so it's non-evaporative and...
None of it expelled?
No.
So it's a constant reuse?
That's right, constant reuse, non-evaporative.
Okay.
Does it require any exchange out, testing, once a year you have to pull it out, replenish with new, any of that required, or is just eternal?
My understanding is the technology allows for it to have a typical lifespan of 10 plus years. Again, our engineer can answer more questions as he's back there, unless there was a major default of the system or something like that.
So just curious on the water technology. So I'm sure you've probably heard some of the comments. Water's one of there's many items that people are concerned about. That's one of the largest. The technology that you're talking about, because everybody hears lots of numbers you can research and certainly go to all the scientists that exist on Google and get all kinds of information about excessive water use. Is this relatively new technology that allows this to happen? When did this become new or different?
It's definitely new technology, and it's become, I think, a more consistent practice with new facilities. So just like other technological advancements that are moving very, very quickly, the manufacturers of the compute equipment itself are looking for new ways to advance how that compute equipment can run, and that's helping to enable the new cooling technology to be able to support these units. So they have a lower temperature. The compute equipment is starting to have a lower temperature, which allows this liquid cooling to work.
Okay.
Your engineer's here?
He is.
Could he come in and explain that to us?
Sure. Shannon.
I had another question. One problem in the rural areas is we're all volunteer fire departments. Is there any kind of training y'all do to accommodate those, or any, maybe help pay for some of that, or
Equipment or anything?
equipment and manpower and training?
I have talked to the commissioner and the judge about that briefly. My understanding is I think you've got 13 volunteer fire departments that serve the county, if I'm not mistaken. And absolutely, at our other facilities, we proactively have brought in actually all of the life safety areas, so police force, sheriff, everyone, fire, to come in and look at how we're going to design the site, make sure that it makes sense for security services, make sure that you understand what the site will look like during construction, so if we do have an emergency, our employees are kept safe. And then working with you on backup fire suppression that we might need and how we would plan for that in the event there was an issue. Work with the volunteer fire departments to find out what resources you need, what training you need, and where we might be able to help support with equipment and other funding. So the answer is yes, and we'll do that as broadly as we can. Shannon, I'll let you answer the question.
Shannon McCall, Telios Engineers. What was a question that I can start with?
Commissioner One.
How does the cooling system work? I assume it's similar to a car engine if you're using glycol.
Are you familiar? So first off, there's going to be 0 to 5% glycol. Like, it's not a lot of glycol because we're moving so much water so much. The risk of freezing is extremely low.
Okay.
So we don't need much of it, right? The other side I wanted to address is we don't change out the water. We sample it, we test it, make sure it's still conducting heat, but we don't ever have to replace it. If I may, it's kind of like the judge changing the air in his tires, right?
That's not going to happen.
Oh, okay. It's the same kind of thing. We just keep using it. It doesn't wear out, right?
So you have large cooling towers, I
So we don't have cooling towers because that's the nemesis, right?
Okay.
We have air-cooled chillers. So it really works much like your house, just on a grand scale, right? Your house doesn't use water to cool the inside. You can have these fans outside and it's moving refrigerant back and forth. Instead of refrigerant, we're moving this water. And so it all stays contained. So we got air handlers just like you have an air handler in your house. You got that condenser outdoors, that's our air-cooled chiller. We got a pump that circulates it, and it's very, very analogous.
So your water coming in is basically going to be a commercial water meter, and you're going to use minimal water.
The Super Walmart, right, with all the restrooms and break rooms and everything, that's the analogy that we're going to have on the site, because mechanically speaking, we're going to fill it the one time, whether she brings it in off-site or not, we're going to fill it one time, and then that's the water that we need for the mechanical system.
How much water is for the one time?
Probably, I'm going to shoot from the hip, sir, 150,000 gallons. It's all just basically the piping. It's six figures, but it's not seven.
Long term, what do you see is keeping the heat factors and
Yeah, so one of the trends, just to clarify, the computer trend is changing very, very quickly, right? Things are getting more powerful. But what the market is doing is all of the computers can start to run at 100 degrees. So a guy like me back in the day, I had to keep the room 70 degrees and keep it cool, and everybody wanted this nice, clean environment. And the computers now, the ones that are talking about in AI, they're getting much more robust. So instead of having to cool to 70 degrees, I only have to cool to 100 degrees. So yes, that means less cooling. That's the trend that the industry is on.
is it going to keep going up, you think? Or
I would imagine those guys won't stop, but we always kind of joke that someday we're just going to have one white box and it's going to do it all, as opposed to a building.
What kind of lifespan for a facility like this?
So the facility itself could last for decades, right? The technology, because it's always changing, the computers are always getting faster. My observation as an engineer is that the equipment's just kind of this slow migration. They don't just like January 1, we put in the new, 2 years from now, we put in the next generation. It doesn't happen like that anymore. It's just, hey, we'll do this small section. We're testing it. They're always moving the compute power around, and it's always evolving. So the building is going to be another concrete building, if you will. It might be cladded like she had up there, looking like the Denton project. But everybody knows those buildings will last for decades. And the cooling system will be a slow change. The piping will last forever, so to speak, of course. I know I'm on record, but.
That building appeared to be real tall. Is that any heat would go rise?
So that was just one design that particular team used. We don't have to use a chimney effect. There's other ways that we can do it, and the Core Scientific team's still working through what that profile is, and I think, again, it'll be part of Town Hall.
Carol, how long has Core been around?
The company was founded in 2017. I've been with the company since 2018, and we have data centers, as you can see from the map, in 7 different states. We've had a lot of very good experiences in Texas and are happy to be here.
So there's no future of building this facility and then Core walking away or selling it to somebody else or anything like that?
No, we've continued to own and operate every facility we've developed, and that's part of our plan, and that's what our board and our shareholders expect from us as well.
If I could, I'd like to shift gears over to power. So there's 2 aspects of it. So the first one, you made mention that you're doing the investment. So you're working with a local utility to set your own transmission line? Is that, and building the infrastructure that's separate from all the residents? Is that what you were meaning?
So the utility for support of this particular project is building a switching yard out by the facility. And that will be to support our project and will likely have some community benefit as well, but the utility could talk to how that will work. And then that will be connected to a substation that Core Scientific will build and own.
So, I'm sure you've probably heard that we occasionally get some really strange storms. Power goes out. We have, with the demand on people and growth, the grid suffers. It's better this year than it was about 3-4 years ago. But any idea with the utilities when you work? Because, one of the things that a lot of people are very concerned about is when things are tough on the grid, how's priorities made? Got a data center that's going to draw a tremendous amount of power. You're supporting companies that contract with you, everywhere, who I'm sure have contract terms for downtime and things of that. How does power get prioritized in the event of emergency with you?
Okay, that's how I will. So I'll start at the top and sort of work my way down. One of the processes that ERCOT will go through as the state regulatory body, they've performed a load study that looked at grid reliability in association with this project. And the only way that they will allow a project to go forward is if they feel like the grid will be reliable. So they've already performed that study, and so has the utility provider. So that's the first piece that was approved in 2024. And then when you look at the way the utility operates, and I don't want to speak on their behalf, but having worked at a utility before I had this job, the utility will have a hierarchy of response. And so in the event of an outage or an emergency or storms, the utility will have an emergency operations center, and they will have a response where they will make sure hospitals are returned to service first, nursing homes, schools, any of those kinds of things, and then we would be last on the list for something like that. A couple of other things that we have that are beneficial. We have backup generators that we can utilize to support our facility. I don't know what those will look like yet or the details of those because we haven't designed the facility, but we will engage in programs that ERCOT has specifically for customers like us that have backup generation to provide, I will call it, a last line of defense before there would be outages. So in the event there was a problem with grid reliability for some reason, nothing related to us, whether it was storms or outages of generation or anything like that, we will be called on by ERCOT to power down our facility in support of their emergency needs. So as an example, during Winter Storm Fern this year, ERCOT had identified customers that voluntarily told them that we have backup generation resources and reached out to us to say, we want to make sure that operationally you're prepared to shut your facility down or reduce your consumption if needed. And that really is to just add value to the grid and to residents. And there are programs out there that I can provide resources on where you can see what those programs are and how they operate since they're governed by ERCOT.
Thank you.
Anybody else?
Well,
Well,
so there was a question earlier, I don't know if it was one of the public statements or whatever, but it's talking about drainage. And I know, and so for everybody's edification, I mean, there's not a plat submittal on this, it's larger than 10 acres, so there's not a plat that'll be coming through for court approval. But I'm curious, do you have an engineering plan for the site, or will you at some point have that? That would talk about how, because it will change drainage in the area because it will no longer absorb as much. Would you be willing to show us, or in the town halls, show people how the drainage will work and what the engineering looks like?
Yes, we will. So we'll show you renderings of what the site will look like, including drainage. It will also include emergency routes for fire purposes and safety purposes. Shannon can talk a little bit to drainage plans if you want to get into the details of what that would be, but we're so early in the stages of this project, we don't have them designed yet for here, but we'll be happy to share them.
I'm not saying we're committing to it, but I know as an engineer, like exactly what you said, we're going to lose some absorption. So sometimes engineers, we solve that with creating a detention pond. So we'll go put the surface drainage into a detention pond, and we'll hold that, and then we'll allow it to do a slow drain after the weather has passed. And we can relieve the general environmental areas. So that might be something we'll consider as we just look at all the studies and get into the details. But that's a solution we go to quite often.
I'm just curious, because or at least I just heard about this project about 2 weeks ago. How long have y'all owned the land? When did you buy the land? When did you come to Hunt County?
So I purchased the property a couple of years ago and just started analyzing it from a power side. I'm an engineer, right? And so the process is slow just to work with ERCOT and the reliability side of it, right? So that study is slow because you have to go through many contingencies. What happens if this generation? What happens if this transmission line goes down, right? And so we just started looking at it and seeing if it was an opportunity. And we started finding the robustness to it. And once we kind of got all of that firm, then I approached Core Scientific to see if they'd be interested in doing their development work.
So you don't work for Core Scientific then?
Only as a consulting engineer.
Okay. So the land is actually yours then?
Yes, sir.
Okay.
Curious, you have probably substantial right-of-way needs. Do you have right-of-way addressed?
We do, sir. Yep. So we worked with Rabiner Electric, and we obtained the easements, and we only had about 200 yards that we needed, because if you look at that graph she had up earlier, there's 4 substations right there already in the area, right? So that made it, the power was logical because of all of the existing infrastructure. So all the right-of-way things were very simple to overcome.
So do you have a long-term lease with Core then?
No, sir, it'd just be a sale.
But it hadn't happened yet.
It has not happened.
Wouldn't it be a conflict of interest, you owning the land and doing the engineering on it?
The only conflict is when you don't tell them.
Okay.
She doesn't have to hire me.
That wasn't conditioned on the purchase?
There was no conditions.
No, so Shannon's firm has worked with us on other data center projects that we have in other locations. His team has done an excellent job with us in our Denton, Texas facility and some of our other facilities. And he approached us with this opportunity related to this project. And as he should, told us, it wasn't conditional on us working with him on engineering, but his team does a very good job. And he knows the community very well and knows the infrastructure and all the details very well from work he's done locally.
Okay. Well,
So is there any permitting or anything like that that would run through the state for a project like this? You talked about permits a while ago, that you've got some or looking into getting some.
We will have, and Shannon can talk to permitting, and maybe that's easier for you to discuss.
I don't think, and it's kind of odd to say it's a permit, but in spirit it is. The ERCOT analysis required them to approve the interconnection. Is there a permit? There's a simple statement that comes from ERCOT that says you're approved for this size that she presented. But beyond that, we're not aware of any other state oversight. Backup generator from the emission side of life, right? So you get into backup generators, and is it a standby function or a full-time function? We're envisioning right now it's a standby function. So the state will look at it, but it's a pretty simple exercise. Thanks.
Well, we are very appreciative of y'all coming in. I know it wasn't a requirement. I'm very appreciative of your willingness to engage the community in town halls. As you talk about the state and things like that, I didn't want to be remiss and not acknowledge that our state representative, Money, is here today. Appreciate his attendance as we try to navigate this and get understandings. There is a meeting tomorrow for this Commissioner's Court to say, okay, we got our first, real input on this, and now let's try and understand where we're at. And this is new to us as far as how we manage it. We certainly will be looking to the state for some guidance and assistance along the way. Curious, do you, in your other locations, do you do any kind of, I hate to use this term because it sounds ominous, but for lack of a better term, public reporting that gives the community a good feeling about what their fears were as you start running a business, that their fears are not being realized? Is there anything that you do like that?
We are a publicly traded company, so most of the things that we do are reported quarterly. I would imagine that there are, I'm trying to think of anything specific that a community has asked for related to reporting, and I can't think of anything off the top of my head. And since my team usually deals with our community relations, I would probably know, but we do participate through some membership organizations and other organizations where we're asked for survey information and we'll answer that. So the Public Utilities Commission of Texas, for example, just put out or is in the process of putting out a survey related to data center water usage. We will actively participate in that and give them answers and things like that. And we're happy to do that. And I can also just mention in relation to this, obviously this is a local conversation, but it's a statewide conversation as well. And Core Scientific sits on a data center stakeholder group that was started by the governor in combination with the Public Utilities Commission and ERCOT. And there are, to my knowledge, 30 key stakeholders that sit on that group, and we're one of them. And the goal there is for them to be educated, just like this process, to understand water consumption and electricity consumption and noise and all the things that you're talking about, and for us to be able to have conversation and think about how we can be value added to the state of Texas.
Is that working group, is there a planned is there a planned output from that, or is it just a think tank?
That is in process, so there are a couple of different pieces of that. ERCOT is planning to provide some kind of an output in June specific to large loads, which will also include data centers. And then I'm sure there will be other components of that will be before the next legislative session next year.
So there'll be some regulatory considerations that will come from them, but you think that's before the next legislature?
That's my understanding of what they've set as their goals, and I'm participating on that task team, but not leading it since it's coming through the governor's office and the other, the PUC and ERCOT. So I know the ERCOT pieces are expected this summer, and then I would guess some of the other things will come in advance of the legislative session based on what they've set out as their goals.
Okay, let's get some public comments if y'all will stand by for a second.
Okay,
Thanks
thank
if they
you.
got questions. Thank you, Carol and Shannon. Appreciate it. Victor Gore.
My name's Victor Gore. Did they say how they're going to generate new electricity or power? How are they going to produce more power and not just rely on that FEC? I didn't hear them say that. They work for a company. Companies are in the business. They have 7 locations. They have 7 states. The manufacturers of the products that they're using now encourage this. They're developing stuff. Well, that's what a manufacturer is going to do. They're not necessarily proven over the long run. You can look on this thing on a variety of folks who say there's problems, there's concerns, there's issues. I worry that Hunt County would jump into something that we've not really looked into. And I know there's limitations to what you can do, but there's also rules and regulations, and we got a state representative who can help us do what we need to avoid making a serious error for Hunt County. We are limited on water, and we are limited on electricity in Texas. I know the state is trying to expand that, but we're still limited, and we can't get beyond that reality. They never did answer how they're going to create more power, and they said they would take care of that. Well, we saw a battery storage unit next to it. That's all that we saw that they showed us. Also, the noise issue. If you look online, you can find a lot of folks talk about that noise. They say they've got it under control. Well, you know, people who are trying to sell a product always tell you that. We need to do our research on our end. We're responsible citizens of our community. We need to do our research and make sure that what we're hearing is accurate enough. Thank y'all.
Thanks, sir. Scott Finney. Scott Finney. There, yeah.
Thank y'all for letting me approach. I came to talk about Epic Meadows, CR2, whatever it's labeled this week. I'll give you a little advice about you as a volunteer fire department. You need to find out how you're going to fight a battery fire. Got a lot of batteries in a data center. There's a precedence here set for Epic in that it's an age-old problem. This is a book called Common Sense. It was written by Thomas Paine in 1776. You'll find at the end of the second chapter, Thomas Paine was focusing on the fact that a constitution was of the people, not of a government. It was the generation of a republic. He stated that at the given time, monarchies were prevalent across the world. But there was a new thing that had just happened in 1774. It was called the takeover of Turkey by Islam. This day it is Islam. He very specifically stated that by no means was it a formidable form of existence for a constitutional republic. That is something I think our representatives, thank you, Representative Money, and thank you for Hunt County Commissioners Court, that you really deeply need to look at. One of the prior speakers spoke on Article 4, Section 4 of the Constitution, specifically stating the protection of the population. That would be the people of the Constitution. That is the job that we elect everybody to do. I moved here in 23. I'm going to be honest with you. I came here because I didn't want to be around Dallas. I lived in Kaufman County 21 years. I liked it. So I came here to get away from it. I'm going to tell you I wouldn't have come here had I known that in 21 and 22, land purchases were being talked about, how we're going to supply water to a 4,000 or 5,000 habitated community, and how we're going to deal with the sewer situation on the southern end of the property. There's no way I would have come here. I wouldn't have come here just because I don't want Islam in my backyard. I live in Clinton, Texas. I'm on the other side of the floodplain from where they're located. My property is exactly due east. Now, I'm not in Josephine, but I don't want it. I don't want to listen to a prayer tower call me to pray on a belief system I don't believe in. I am greatly encouraged, Bobby, that y'all opened in prayer that says, "In God we trust." Thank you. We are a nation under God. We are a Christian nation. But I've got a whole bunch of stuff here. It just don't smell right, guys. You got a memorandum written in the 80s, takedown of America. I've got an engineer study that began in 21 and 22, and none of that matches this. The meets and bounds, totally different. By the way, in case you didn't know it, The plat system in the neighborhood is broken up such that the voting constituency is in Hunt County. It ain't in Collin. The business side's in Collin. I've got the plat. I've spent 52 years in the construction and development business. I built Firewheel Town Center. I've done developments everywhere. And you don't do MUDs this way. Josephine is currently involved with 11 MUDs. They're all legitimate. The MUDs that I've worked with, we actually prefer to do it the legislative way. It's a lot quicker. It also is a whole lot more public, as Congressman Money will tell you. But we can get our deal through faster. Now, if I want to hide it, I go through the TCQ, but it takes 18 to 24 months. And guess what? The fine people of Hunt County, unless they get the meeting notice, they don't know anything about it. Surprise! I'm pleading with you as a taxpayer of this county, an inhabitant of this county, whatever you can vote against, whatever you can turn against, you need to do it. You need to do it because it's not in the best interest of our country. It's common sense. These guys say it's great today, but in 30 years, we're going to kill you. You're either going to convert or we're going to kill you. I won't find that in the God that I worship. I know it's not in your Bible, Bobby, because I can tell how you prayed. So I'm asking everybody here, including Congressman Money, go to fight. We got a set of laws that were set up, and we set it up based on capitalism. But you know what? These guys showed up, and they don't work like us. Now, Brent will tell you we do business this way. We do developments for profit. That's why we do it, right? It pays taxes, it buys fire trucks, and it keeps Hunt County in plenty of bottom dump trucks. But I will tell you, that's not what this is. It's not this in any county. Right now, Kaufman County shut it down. I've gotten a phone call from everybody that's had to deal with this problem because of where I live. Blue Ridge shut it down. Keller shut it down. We got to shut it down because we're going to end up like Ann Arbor, Michigan. By the way, the funding you will find Community Capital Group is funded through an old line bank out of Ann Arbor, Michigan. Don't take my word for it. Go check it out yourself. But why are we covering it up if it's so legitimate? Why? So I'm asking you guys, listen to your constituents. We got a lot better deals coming down the pipe. This is one we need to let go on. Let's pass it up. I don't know how you're going to do it, but find out how. Legislator Monday, you need to put teeth in the county governments. Unfortunately, we cannot do business like we used to could. I can bring a deal, we can develop it, everybody makes a little money, including the guy grading the front yard for the St. Augustine grass. But we're not in that anymore. We've got people that have come into our country. They're using third world financiers, Qatar, Saudi Arabia. I can go on, the list is endless. Communist China. And they don't have our interest at heart. That's not what they're here for. I can't tell you how much I appreciate y'all for letting me talk, but please step up.
Thank you for your comments.
Thank you.
Jane Ridgway? Oh. You-
Sorry about that.
No problem. I want to leave mine a lot of
Are you
times.
going to take that against the next time I want to
No.
talk?
We're at item 23 already? Did I miss something on the?
Oh, no, I just had you in the stack for the current one. If you want to wait, well, you can wait, and I'll get you.
I'm just gonna go for it.
There you go.
All right. Where do I start? Transparency. I'd like to see the plat. That's why I was waiting until 23, just to see what it looked
Right.
like. The reason being, I heard the word Crescent Meadow come up today, along with Meadow. So I'm not sure if there's something different going on. But if you guys approve this plat, there's still a chance that they could maybe annex into another city. And I would rather not see you approve a plat that it may go into another city. The other thing I'd like to see is, where are they going to get their water? I'd like to see the flood study. None of that is transparent. When we have in the city of Josephine somebody that comes in for development, everything that's on an agenda for our city, the citizens can see. Packets 300 pages sometimes. Our citizens can sit down and see what's going on and what's in there. We don't have any of that here. And I can't improve on anything except to say, if you approve this, it's definitely going to affect the infrastructure in Josephine. I live at 5754 FM6 in the Hunt County side of Josephine. My deed says Caddo Mills. So Hunt County's always been my county. I don't want to see this happen to Hunt County. And there was a stay put on. There's a lawsuit against these people. Can we approve something that there's a lawsuit against the people that are trying to create a plat? That's what I need to find out. Because Ken Paxton stopped a meeting at Epic Center. I went over there to make sure that it was stopped. Can you approve a plat if everything is in something going on at the state level? And anybody who doesn't like how MUDs are made, they need to contact TCEQ and tell them to quit rubber stamping and splitting MUDs out to make more MUDs without anybody even looking at anything. And I guess that's about all I have to say, because we need some help to get things at the state level so our representatives can actually do the things for us.
Well, I agree with you. TCEQ is a rubber stamp on everything they do.
It is a rubber stamp.
They tell you, if they bring in the plans, it follows their rules, they rubber stamp it no matter what it is.
They don't even, I can tell you from experience, I fought four now.
We fought several
They don't
ourselves.
even fill out the applications right, and I point those out. That's not important. Rubber stamp.
That's it. You're right. You're 100% right.
All right, that's all I have to say.
Thank you.
If there's a lawsuit, don't think it's...
Is it Carl Crawley? Okay. Gary Marshall? Okay. All right. Anybody else wish to ask questions or speak? Come to the mic. Give your name.
I'm Carol Davis, a resident of Hunt County, and I was asking if I could just ask a couple of questions regarding the presentation about Core Scientific.
Sure.
Okay, in the young lady's discussion, I didn't hear her talk about the air quality impacts of potential nitrogen oxides from the combustion of the backup generators. And importantly, we are upwind of the most pollution sources in our area of Dallas and Fort Worth. This facility will also be downwind of me in Commerce, Texas. So I'm concerned about the particulate matter in particular. Yeah, I'm sorry. Maybe that was an emphasis, but because of the EPA's lowered standard for particulate matter, which kills thousands of people every year, unbeknownst to them, especially during the winter when the nitrous oxides are in the air combined with the particulate matter. It's the little particles that can carry toxins, but I know they are saying that they're going to use electricity, but somewhere there's going to be that particular matter generated in nitrous oxides. But
well, let's get them up here to answer your question. Is that all you have?
No. Also about the the drainage, the stormwater drain, if there's, what is going to be released from the facility.
He
I know
talked,
you
he
were
talked
cons-
to us about that. He's having a detention pond that'll release it at the same rate as it currently releases it.
And
And that's
Releases it where?
Where it originally was headed.
And there will be no toxins in the water that's discharged. I mean, that's something the EPA would be concerned about, I would think.
We can get him to try to answer that.
And I know this may not be important, but I noticed that it's only 70 acres of a footprint, and then yet they bought 268 acres. So I'm wondering if they had any plans for future data centers there. And I don't know if y'all are aware, from what I read, and correct me if I'm wrong, is that Core Scientific experienced some kind of bankruptcy action. I think they pulled out of it. But, I mean, your question about the finances of the company is important. And I guess that's, and of course, the disruption to the local habitat of the animals that traverse. But sure, people can buy land and do what they want, but I think there needs to be a lot of mitigation, that the company is a billion-dollar company, a multi-billion-dollar company, and there needs to be mitigation to protect certain things, you know. Since Hunt County, as far as I know, has not done a whole lot with the air quality improvement plan that's being modified currently. I asked AI, of all things, if Hunt County submitted any comments in the period ending around March 10th that the North Central Texas Council of Governments is doing. I know Kerry Crews is our representative there, but since I'm his political opponent, I won't say anything more.
Well, I need you to wrap it up. We got to move on with that.
Thank you. Those are my main
You bet.
concerns. Thank you.
Thank you. Shannon, one of y'all Carol, you or Shannon want to address some of those questions for us? I'll get to you. Let's get these answered first.
So on the emissions, definitely an engineering analysis still occurs. We definitely look at the same particulates that she was addressing. We keep them clean. I agree with their EPA standards are lower, and it doesn't mean that Core Scientific has to lower them either. But it's definitely a technical exercise that we have to work through. So that's what we'll be doing. That's what we'll be sharing on future town halls. In regard to the stormwater, yes, we can do detention. I don't know if we will, but it's a very good solution. And even when we do those, we can actually filter those as well. And all of it is taking samples, understanding what their particulates now in the water, and we can do filtration there too.
Okay.
Was there another one?
There was a couple of other questions. I think I captured them as the people were going through them. She also asked, are there plans for the future acreage that is currently owned?
So, I don't know, Carol, if you want to take it, but what I will say is the market is trending smaller. As I shared earlier, the power in these computers going higher and higher, meaning we need less square footage. So to program what it is, and of course she needs to speak for her own visions, but I can just tell you as an engineer working in the data market, all of these buildings are trending towards smaller.
The other one, the first gentleman asked, how will you generate your own power? That was the first question.
So the on-site power, again, it's still be an engineering analysis that we start to work through. Ultimately, Core Scientific will have to procure their power. I know many times they've actually looked at renewable resources. The transmission is available because we did all of the analysis with ERCOT. So it's not an answer that we have today. Again, we're early in the design and the programming process.
So I'll try and follow up to his question of what I think he was asking. So, but you'll be working with the utility company, you'll be getting energy from them, electricity from them.
Yes, sir.
It's not necessarily your energy, it's just that they're going to create the capacity to support your demand.
That's exactly right. But in the competitive Texas market now, there's a lot of resources for that energy.
And so were you going to, or were they going to provide any on-site?
For backup power.
Just backup?
Yes, sir. Yes, sir.
All right. Carol, you coming up to say anything?
No, I just wanted to be here.
Oh, okay, that's fine.
Moral support.
All right. Thank you for now.
Yes, sir.
One more? Okay. I think I'm through with the sheets, so come forward, state your name and address for us.
Hello, Carissa Sanders, 6400 Stonewall Street. Okay, this is about the sound, all the decibels here. Is the measurement average or peak? Is it daytime or nighttime at a property line or at the nearest residence? Whenever she was talking about the decibels, it being like a whisper or chatter, where is that? Where's that measured at? And does it include all operational equipment? Or is it just, there you go. That's all I had.
Okay. Carol, can you put that slide back up that showed that? Maybe that'd help. I don't know if that'll answer the question or not, but maybe.
I mean, this doesn't talk to the necessarily the this project specifically, just in that we don't have readings yet because there's not a project at the site. So
Okay.
this is talking about our other sites and the sound levels that we've done at our other sites, and we will measure them here. But the expectation is that the nearest existing house will be the 40 decibel level. Near the county road, which would be the perimeter of the site, would be at the 60 decibel or conversational level. We still have work to do on the site design that could even help to further mitigate that, such as adding different landscaping capabilities, whether it's a tree line or a berm or other types of landscaping that could help to further reduce that.
Does it get louder at nighttime versus daytime, or is it a constant, the same decibel level 24/7?
It should be pretty consistent throughout the course of the operations.
What changes that?
If we were to need to utilize backup generation or something like that in the event of a storm or a called-on outage by the utility, then that could increase. And we will run those tests and provide that information. We're early. I'm not even in a position, since we don't have the site designed yet, I don't even know how many backup generators we would plan for the site to be able to say what the exact sound level would be, but this is a representative of our typical data center sites.
But as I think you mentioned earlier, as you mature your design, you will be willing to come back however many times needed to communicate the latest level of information.
Absolutely. We're happy to, we will begin the planning for town hall meetings where we can provide what I'll call more hands-on information, so we can have demonstrations of our closed loop chiller system so people can see them and see a video of them. We'll have information about sound level from all the different sources, and we'll provide more data points.
And back to the question, so really your noise is an average decibel because it's a constant. So you don't really have peaks that go higher or lower in an hour, in a 2-hour window. The only time you see your dBs possibly going up is in an emergency where your generators would kick on.
That's right.
I know there's still some more questions out there. What kind of time frame are you guys looking at? I know, Shannon, you said you bought the land 2 years ago, and now it's finally starting to kick off. So what kind of time frame are you looking at to be able to come back to the public with some more information?
I think we can plan to have a town hall in the next month to 2 months, just depending upon what works for the community and key stakeholders here, so we can plan it in a way that everyone can attend. All of that, in terms of civil planning and civil work starting and things like that, I would expect that to be in the next 6 months. That'll be early phase planning and things like that.
Can we do that in the evening where more citizens can attend if they want to?
Absolutely. Well, we'll do it in the evening, and why I say, engage with everyone is to find out what the right locations are for those meetings and where it's easy for citizens and business owners to be able to get to.
Okay. All right. Was there one more? Let's get one more up here, and then two more. Hang on a second.
Sandy McCary from Country Oaks here in Greenville. My question is, how many lawsuits or legal actions are pending against the company? I went online this morning and found 3. One where A workers' comp lawsuit was filed in October because of a transformer explosion. How would that be addressed? Core Scientific strikes $14.75 million settlement in investor SPAC lawsuit. And court ruling intensifies focus on Core Scientific's pre-bankruptcy operations amid patent infringement allegations. And how would that affect this facility?
Okay. Carol, can you?
I am not an attorney, and I do not want to represent the facts of any of those cases that I have not been involved or engaged with. I'm happy to provide resources, provide commentary at a town hall meeting, but I am not familiar with those cases. And
Fair enough.
okay.
Okay.
I would just be prepared to come back to answer that.
Yeah.
Oh, absolutely. I just don't want to misrepresent anything.
No, I understand.
Appreciate that you don't.
Dana Locke, I live at 7410 Hideaway Park, and I was wanting to know if if Core Scientific was in charge of the other data center that's going in near Quinlan. Are you?
This is the only data center project we have planned. I'm not familiar with anything else.
There's supposed to be another one going in Quinlan, and I'm worried that having two so close together is not.
Would be addressed Quinlan. That one would be addressed. The address would be Quinlan, correct?
the one that
I don't
I
know if that's
So,
Quinlan. Is it Quinlan?
The second one that we've discussed, I probably got from me online, is one that we have not met with yet, but they have asked for a meeting. And so we are getting information from them, but yes, it's north of Quinlan,
Yes,
is my
uh-huh.
understanding.
And is that going to affect more of our electricity because of having two data
We-
centers so close together?
We haven't had a conversation with them yet.
Okay, well, that's.
So we don't know.
Yeah, but it's a
And
fair
they're
question.
actually, their property's in the Lone Oak School District. So I don't know if they have a Lone Oak address or if they have a Quinlan address.
Well,
Is Quinlan address? Okay.
okay, the Quinlan that I'm talking about is directly west of Bull's home.
Yeah.
That's the site.
Nob Hill,
Yeah.
general area, yeah.
Yeah. Hang on just a second. We got a lady right here. Yep, if you had a question?
Nikki Peterson off of 1564E. I didn't hear the answer to your question, sir, about the rest of the acreage usage, unless I just misunderstood it from him.
I think what he said, I'll ask him to come clarify, is that they have no demand for that property at this time. I think that is,
What
that's
about
what
future
I.
demand?
Yeah, well, that's.
Who knows
Shannon,
what
would
the
you like
future
to-
is?
And the second one is, has there been a shutdown of any of these prior facilities where you've had to use the backup generators? And what does that sound like? Are you understanding the question?
I do. So at this time, we do not have any plans for the other acreage. I don't know what the future holds for density of compute equipment. I know that as of right now, the footprints are getting smaller and computer density or the ability to process computers inside the facilities are becoming less land intensive, but I don't know what the future holds. So as of right now, the plan that we have and that we will show you when we come to town hall is specifically related to that 70 acres. And then the other question, if I understood it, I just want to make sure I answer the right question, was have we had the ability to use or requirement to use our backup generation at our other facilities, and what does that sound, what's that sound like? I know that we have tested backup generators at our other facilities, and I know that we do decibel testing. I don't know the answer to all the details because it's also related to the quantity of the backup generators being tested and utilized. So I can provide more information on that, but I don't have a very specific answer.
And so the continuation of the acreage.
Hey, you need to come up to the mic, please. I'm sorry.
I'm sorry.
We're broadcasting. We got to make sure everybody hears.
That's my mistake. So. And the mic. But I want to have eye contact. That's a big thing for me is eye contact.
You can take that mic off.
So
Pull the
why
mic
would
out of this.
anybody buy that? Let me stop.
That's what squaring up.
At other facilities, have they purchased this much land, this much extra land, like he's done here? And if so, with previous locations, what's been done with the land? There's got to be some sort of thought process behind land you purchased further than the 70 acres. There's got to be.
Well, I'll say, from being in the real estate business for nearly 40 years, a lot of people buy land just on speculation, and it's going to keep going up. And this case, he's found a user for it, but he doesn't have he's saying he doesn't have a user for the rest of it. You know, it could be, you know, who knows what's in the future. I guess one question I had on the size of the computers, I'm old enough to know I had to carry a bag phone when I got my first phone that barely worked. And now this is more powerful than my computer at home. Do we see the scale down of these computers in the future? Shannon, that's a question for you.
I'm just talking about expectation.
Yeah.
Of that.
So first off, it was a speculative buy, and there's no harm in doing a speculative buy. There is no vision. There was no vision. I'm an engineer. I saw a substation. There had to be opportunity, but it was going to take time to figure it out. So I bought the land because it was near a substation. The family that owned it, the patriarchs of that family, granted easements to the utility companies. That created the attraction. What happens, though, is so TBD because the market is changing so much, right? There was ideas of solar, right? Solar doesn't make much sense anymore, but there was a day that it does. Does it come back? I don't know. Batteries come in and out. It was absolutely speculative, but there's nothing wrong with being speculative. Computers coming down in size. Those computers that are doing AI now are a couple inches thick. They're the size of your lab drawer at your desk.
Wow.
They're getting small.
Wow, amazing. Okay, Commissioners, y'all got any more questions? I'm gonna close the public. We got one more, and that's it. And we're just gonna take one more. We've had lots of questions.
I'll make this quick. My name's James Barrett, 415 Bethel Road. So I live at the end of the new Roy Warren Parkway where they deforested 100 acres to put in a subdivision. Well, they did the retention pond. They released it out at the rate that was supposed to be the same as before. However, Bethel Road, they had to increase the culverts by 333% to manage the same amount of water after it comes out of the detention pond to not flood the roads, because they built the detention pond. The 3-foot culverts that were there weren't large enough to handle the water quantity, so they had to, R&R Utilities happened to be the subcontractor. Anyway, increase it 33%. So the retention ponds that they say, there's proof out here in this county that it doesn't work the way that they say it and show it on the plans.
You're partly correct.
Yes, sir.
But you're partly wrong. The pipes that were under it never took care of what was above it already.
I'm a third-generation farmer there, so we've got.
I got you by generation.
Yes. Oh, you've lived there too. Gotcha. So we buy in this county 30 megawatts of power. So GEUS buys in 30 megawatts. They're adding additional 430 megawatt requirement to this county. So where are we going to get that? We're already buying in 30. Mm-hmm. We're going to buy in another 430 on top of that. So that's a big issue there as far as the power consumption comes. Excuse me. Now then, let's go to the operating temperatures for the cooling systems. Yes, they've gotten a little bit better than what they have. I'm an IT guy, U.S. military. I've done this my whole life. So, however, just a simple Google search using AI to tell me what data centers are operating at. 100 degrees is the top end, 113 being the absolute max. However, the normal is approximately 70 to 75 being optimal, the higher temperatures being 80 degrees. So telling me that you're going to run at 100-degree temperature cooling, I don't believe that. AI is telling me completely different right here. Thank you.
Thank you. All right. Commissioner, you got anything else?
One, and if I'm out of line, you can tell me. I would be curious, and not to put anybody on the spot, but we do have a state representative here today, and I would be curious if there's any input from a state perspective that you have. If it's not the right time to ask you that, just tell me so.
Boy, that's a very good way to say it.
Thank you. I'll try to keep it short. First of all, I'm learning about this about as fast as all of you guys are. So I'm not standing here as an expert who has it figured out and trying to tell you. I'm looking forward to working with you guys as we figure out how to do this with the counties. But I have a few things. Number one, we did pass legislation last session to address in a large way power in our state, not just how to develop more power, but how these high users have to interact with the grid. I don't understand it all. I hope nobody asks me any follow-up questions. I just know from the people that said that were putting it forward in the past, you can't just say, hey, we need 437 megawatts of power and not take care of how that interacts with the rest of the grid. We need to continue to generate a lot more power in the state, or we're going to be behind. And we've known this for a long time. China's been building a coal plant every week for a decade and a half, while we've been decommissioning everything and building wind and solar that doesn't do squat. So we have some catch up that we have to do, or we're going to lose. Same is true with AI. We can't say, well, we're scared of it, we'll just let China develop it. That is a recipe for disaster. It is a good thing that Texas is leading in AI. And we're talking about 1 or 2 in this county. I would imagine when you look up a decade from now, there's going to be thousands of data centers in Texas. Now, what it's incumbent on us that have been elected to protect the people is to ensure that that's done in a responsible way. And my focus is, obviously, we need to focus on power, water, and I think those are critically important but pretty simple to resolve. I think that the difficult questions to resolve are just we need to maintain the rural fiber of Texas and farmland and agricultural land and not put a data center on every 100-acre farm across Texas and not be able to raise cows and grow crops. And so, and just have a quiet place to fish and hunt. So I'm looking forward to any opportunity that y'all have to invite me into these conversations, or any opportunity that I have to invite you into these conversations. It's really important. I have some ideas, and I know other people have ideas as well as we try to navigate this. But I want to thank you for inviting me here today and for giving us a chance to talk about it.
Thank you for attending. All right. Gary, you done?
I'm done.
You sure you're not sitting over thinking? You got that look on you. All right.
I've got a list, but everybody's covered it pretty good.
Okay. All right. No actions required on this, so we'll move on to action item number 6. Discuss, consider, and approve resolution adopting required CBDG civil rights policy sent to us by Grant Works. Entertain a motion for approval.
So moved.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 7, proclaim April as a Fair Housing Month. This proclamation will be helpful to fulfill fair housing activity obligations required by the grants. This is a requirement of our grant with Grant Works. Entertain a motion for approval.
So moved. Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 8, change order number 3 to the L3 Harris radio contract modifications to be discussed for approval. Virginia, still here. Okay.
This change order was actually approved back in October of 25. There were just some modifications to it. It doesn't change the price of anything. The only thing it changed was there was a subcontractor that's no longer working with our county anymore. So we took that subcontractor off of the off of this change order. And then there was an error on the in the math on the pricing. We fixed that error.
Okay.
Again, it doesn't change anything monetary for us.
All right, any questions? Entertain a motion for approval.
So moved. Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 9, discuss and possibly take action on a software feature for the volunteer firefighter radios that would allow the toning on a quiet channel.
All
Whatever that means.
That's why Biggers is here.
He's over there in the corner.
Okay. So when we bought these radios, a year or so ago, the toning feature that would open up the channel whenever they put it on the quiet channel, like at nighttime, so that they're not getting toned out. For every call across the county, they're only getting their tones. That software feature was not available. It was not a feature that was compatible with our system at that time. However, L3's come out with a software feature that will make that toning compatible so that they will not be hearing tones for every department across the county. However, that software feature comes with a price tag of $110 per radio. So,
What's the final number?
okay, so we did some just, David McLaughlin at AMR and I looked at it, and he looked at it from an operational standpoint and said if we went through and we wouldn't have to do every single radio, but these are the radios that if we did these, roughly around 30,000. So then take a breath. Talking with Biggers, we looked at it as just to kind of cut cost, obviously, is taking out, doing just the base stations. Those are the ones that stay in the inside the department, and just a mobile radio that sits there. Putting it on that one, and then if we did 3 per department, roughly that comes out to around $5,390. If we did base station and 2 handhelds per station, comes out to $4,070. And if we just did base stations, you're looking at $1,430.
How many have base stations?
Every
Everybody?
single one of them.
Every station? Okay.
And this is just for fire departments?
Yeah, it's just fired.
Okay.
So all of them don't take radios home, do they?
Chief Biggers, I know you've been waiting so long to get up here and speak.
Yeah.
So here's your time.
I got voluntold to be here. Like I said, the toning works as we listen to the radio during the day a lot of times, but then when the firefighters are asleep at the stations, the radio goes on what we call a silent page channel. So in the back, it's not broadcasting over the speakers, but then that channel is listening for the tone. And then when the tone on the main channel happens, it opens up the radio and alerts the firefighters at the station. And so it uses station alerting. So that would be the benefit of every base station having that for when they have personnel there overnight. Some stations staff 24/7, some not. And allowing for just 3 handhelds to have that ability would allow departments to have at least 3 individuals that would have a handheld that would be able to go in silent mode if they had utilize that handheld and apparatus if they were taking it home or whatever, to be alerted. So, because currently our alerting system through cell phones is not very adaptive. We have what's called Active 911, but it does not alert. It's not very collaborative with the AMR CAD. It doesn't work to its fullest extent that it could. So it has a delay in setting off a cell phone and things like that. The radio is the most consistent and doesn't have downtime and fail.
So is that on their current, and they upgraded yet? I thought the AMR was going to upgrade their system.
Their system is still called Logis. It's a CAD system. It's still designed to dispatch EMS and do ambulance services and transfers. They've modified it some to adapt, but we're the only fire service they dispatch, so they have not purchased what would be known as a fire service CAD part of that, which costs well over $100,000 to update. So they haven't done that. They modify it the best they can to adapt to us.
So they adopted the P25 radios yet, or what?
Yes.
Am I saying that right? Am I asking the right question?
Yeah, pretty much. We're getting pretty close. We installed our last fire radio today down at West Tawakoni. So now that we've got all the radios installed in the apparatuses, we're going to start working on getting those the portables programmed. And so I'm just kind of waiting to find out what we're doing with toning and how AMR is going to be doing their dispatch so that I can build that personality and program.
Well,
Once I get that done, then we'll be passing them out.
It was my understanding, once we got our system up, P25 compliant, they would be changing theirs to come up to the same.
As far as radios, yes, Judge, they have purchased the radios. They are in par to be able to use the system. It's just waiting for the system to be finalized and go live. They have the radios in place, yes.
So them having that doesn't help this situation then?
No, sir. They have to tone. The tone's a separate thing.
Okay. That's what I was trying to understand. I'm sorry. I was just trying to understand it.
It was initially, and I remember Commissioner Harrison was probably in the meetings where we talked about this. Harris was kind of telling us that it was going to happen, and we thought it was a case of it was going to happen. And then they came out just recently like, oh, well, no, it's an update we pushed, and you'll have to buy it, but you already bought all your radios. Sorry. That's kind of what ended up happening.
So, Chief, as the president of the Fire Association, what is the recommendation from the association?
To try to keep costs down. We understand that it's to the point of not wanting to sit there and put up at a $30,000 mark. Current recommendation would be base stations and 3 handhelds. We feel that would allow for fire department coverage to be left adequate.
What was that value? What did that cost us?
$5,390.
And
Estimate.
And would that be our plan, or would that be right now in this budget year, we do 5,000 and we'll have to catch up with the rest of it later?
Our plan would be, would still leave the department's options to, if they can, come in and, with fundraising and cost, effectively help upgrade the rest of their handhelds if they need them to be. But it'd be kind of that cost share. The county would get us initiated, and the departments could come in and have to, and
So you
help
do
upgrade.
need to expand it to the full.
Yes, but currently, this would get us operational. If departments were able to come up to budget, we'd give it to Virginia and say, hey, we can pay for 5 more to be done, and maybe cut that check or however it be. So, or if the next budget year it wasn't happening, we may be able to have to come back.
In Virginia, you do all the programming for this, correct? Okay, so there's no cost for that or anything?
No.
Okay.
Virginia, this may not be a fair question, but how many more change orders do you foresee on this project?
Actually, I do have one more, but
Today? No, we didn't.
I do have one more that's on the books, but it does not have any kind of there's no monetary value attached to it. It's just L3 is wanting us to go to a system conditional system acceptance. So we just have a handful of things that we're still working on getting done, but we are fully operational on our system. So per our contract, there's some stuff in the contract that they're wanting us to kind of move forwards, and it does include one of the milestone payments from the original contract. And we've negotiated a little bit with that, but there's a couple things that I'm trying to get finalized before I bring it to you guys.
Okay, just so the public knows, we purchased a new system starting
22 or 23?
23, I think it was. Our old system been here, it was an antique, it'd been here a long time. We had spots in the county where there was no radio communication. We have deputies out on a foot chase and they can't communicate back anywhere. So this new system, we can cover the whole county. And plus we're locked in with, we've got the same system as Rockwall, Kaufman,
Van
Zant, and also if the sheriff's, I don't know, in a high-speed chase crossing county lines, they never have to change the channel or anything. It all stays where it is. So it gives our law enforcement a lot of advantages they didn't have, and it was money well spent to get. If we can save one of the deputies' lives, it's worth every penny. So.
And we've incorporated the fire departments as well.
Right.
This radio system.
So it's the newest and latest P25 that was supposed to be required to be in. Everybody's supposed to have it like 10 years ago or something, a long time.
P25 is a standard. This system does comply with all the P25 standards.
Right. It gets us up to date where we should be. All right, any questions, Commissioners?
Where would the money come from?
We'll have to take it out of contingency. Capital improvement. No, we got contingency in our budget. We'll probably have to take it out of that.
I'm good with the base and the 3 handhelds based on the recommendation from Virginia and Chief Biggers.
So it's the 5,000,
390.
390.
That's my math. I haven't put that to a
Virginia.
quote.
And to be,
Y'all know how I do math, so, but,
It's usually figured low.
well, the base stations, there's 13 base stations, for each, so one for each department. And then if we did 3 per department, you're looking at, 36 radios. So times 110, that's the math I came up with, in case you want to check me.
all right, so up to $6,000 out of contingency to cover the cost of
Thanks.
this this request and
Going
any
once.
math errors that might have happened.
It's fair.
Yeah. Steve, is that in your motion? Is that,
Yes, I'll make the motion for the base and 3 handhelds for up to $6,000 for reprogramming.
and be paid for out of?
Contingency.
Yeah.
That's a motion.
I'll second it.
You got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 10, an agreement with we're tabling this, aren't we, David?
Yeah. On this one, I make a motion to move this to the meeting on March 26th at 10 a.m. To postpone.
Postpone till then. Correct.
Need to make a motion to postpone till the meeting at March 26th at 10 a.m.
Second.
Got a second? Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 11, the request for permission to install electrical distribution facilities in the county right-of-way on County Road 1027 under normal stipulations. Entertain a motion for approval.
Make a motion.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 12, the upgrade of approximately 2,307 feet of County Road 1047 from dirt to rock at county's expense in Precinct 1. Entertain a motion for approval.
So moved.
Second.
Got a motion second. All in favor say aye.
Huh?
Can I make a comment on this right quick?
Yeah,
Sure.
Get a motion a second.
We got a motion second discussion.
It's been, I'm not trying to be a jerk or anything on this, but over the last 3 years, I've been against upgrading roads at county's expense because my stance on that is we have so many roads that aren't up to par, what they need to be. And so I think that we need to get the roads that we currently have, get them up to good condition before we start upgrading more roads to a different surface. So I'm opposed to it.
Okay. Any other comments? You got any comments, Commissioner?
No, I ain't mad at him.
Sorry if you are, but I gotta say how I feel.
Oh, y'all had to sit by each other too. That's a deal. All right. Any other? Commissioner Smith, you always got a comment.
Yeah, I'm not gonna comment.
Okay. All right.
And let me go ahead and just say it. The reason I am against it is because in Precinct 2, I take in around 40% of the revenue. And we split the money evenly. Everybody gets 25% of the money. And so that's why I'm against upgrading roads, because I barely have enough money in my precinct to keep potholes patched.
Well, we sure don't have enough money
So-
to keep our vehicles, take care of all the upkeep from the road conditions that we currently have to live under. And we don't have any power at our own house to change the road condition. You have the power. I've had to replace 2 cars and motor mounts on a Harley.
Ma'am, you
50,000 miles on it.
you need to come up and state your name and get on the mic if you.
Well, I already stated my.
I know. I'm sorry. I should have caught you quicker. It's my
Yeah.
fault.
My name is Melanie Cook. I live at 3922 Long Island Trail. I'm in Mr. Harrison's precinct, and it's like a third world refugee country down there. You can't get, there are roads we couldn't even look at a house that we wanted to buy back in 21. We couldn't get down the road, like legit. So we live near Hawk Cove. That's a nightmare. We're an unincorporated county. You guys have $60 million sitting in the bank, and we're stuck with car repairs from the terrible roads. I mean, it's real hard to listen to.
My budget is $4 million a year is what I get, and that's for everything. My road material is $2 million. I have 250 miles of road. That's $8,000 a mile. You can't build a driveway for $8,000. So we have to be very creative. It's not that we don't want to do something, and I'm not against upgrading roads. What I am against, and my whole point is I'm taking money from my constituents in Precinct 2. We're dispersing that money around. I'm okay with that. I understand that we have to do that to make it work. But I'm not okay with upgrading roads in other precincts when my precinct, I'm doing all I can do to keep potholes patched.
Well, that's fair. It's just, I spoke out of frustration, of course. But the first two things that ought to be taken care of inside any defined area of constituency is safety and roads.
Well,
I feel safe, by the way. I'm very safe.
Did you say you were precinct 4, or do you live in Hawk Cove area?
No, I live in precinct 4.
Okay.
I'm unincorporated.
What was your address again?
9322 Long Island Trail.
So for the public, on the money and all, I spoke recently on our State of the County and read a proclamation, I wish I had it with me, that Judge Ransom in Cass County has sent around, and I can't quote every bit of it, but I can get the high points of it. And we've adopted that resolution. The resolution is sent it to the state along with most other counties. In 1954, the state imposed a gasoline tax on every gallon of gas bought, and out of that tax, they gave the counties $7.5 million to be divided between 254 counties in some way. Today, they still give us $7.5 million. And they take in, I don't remember, it was $3.8 billion or $8.3 billion that we pay for in Hunt County with our gasoline tax, and they need to give us more money so we can take care of y'all's roads. And everybody needs to write a letter to their senators and their representatives and say, we want this changed, we want it done. We got to fix the lateral road system so we can fix some roads. Because it's so costly, nobody wants to pay any more taxes. I don't want to pay any more taxes. We got to have funds from somewhere, in the state that's 70 years. They have not changed that allocation. That's not even fair. Not conscionable they should do it.
So we're currently in a budget year.
Yes.
And so Commissioner Money is spending money within the budget year. This is your plans, the things that you're going to be upgrading, or these things that you're catching up?
This is a little of both. I don't remember which one's which, but one of them was already done. The other two I am doing. Both of them are safety items. Both of them are dirt going to rock. Both of them are dirt between two rock roads. I'm having constant calls about Amazon, delivery people, big trucks using Google Maps or whatever and getting stuck on a dirt road. I'm trying to eliminate dirt roads.
All right, any other discussion? All in favor say aye.
Aye.
All opposed?
No.
Motion carries with one no. 13, upgrade of approximately 3,540 feet of County Road 1110 from dirt to rock at county. We would have to do that right after that. The county's expense in precinct 1.
Make a motion.
Can you say ditto?
I was going to say I ditto everything I just said on 12.
All right, we got a motion.
Second.
Got a motion second. Ditto on the conversations. All in favor say aye.
Aye.
All opposed?
No.
Motion carries. One no. Item 14, upgrade of approximately 2,460 feet of County Road 1104 from dirt to rock at county's expense in Precinct 1.
Make a motion to approve.
Ditto previous
Second.
conversation.
You had a motion, second. All in favor, say aye.
Aye.
All opposed?
No.
Passes with one no. Action item 15, the request to construct electrical power distribution facilities at Cross County Road 2162 under normal stipulations in Precinct 2.
Motion to approve.
Second.
Got a motion, second. All in favor, say aye.
Aye.
All opposed? Motion carries. Action item 16, the request to construct electrical power distribution facilities that will cross County Road 2532 under normal stipulations in Precinct 2.
Motion to approve.
Second.
Got a motion and a second. All in favor say aye.
Aye.
All opposed? Motion carries. Action item number 17, the request to construct electrical power distribution facilities that will cross County Road 3602 under normal stipulations in Precinct 3.
Motion to approve under normal steps.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 18, the request for permission to install electrical distribution facilities in the county right-of-way on County Road 4614 under normal stipulations.
Motion to approve under normal stipulations.
Second.
Got a motion and a second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 19, the request for permission to install electrical distribution facilities in the county right-of-way on County Road 4615 under normal stipulations.
Motion to approve under normal stipulations.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 20 is postponed to be
Yes, it's postponed.
removed. Okay.
Removed it.
All right, number 21, the final plat of Dallas Miriam Temple Edition in Precinct 3. Brian, you or Daniel starting with this?
This is a simple two-lot plat that's in the Lake Tawakoni Zoning Commission area. In your packet, you've got a recommendation from the Zoning Commission to approve this.
Okay. Any questions? Entertain a motion for approval.
Make a motion to approve.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 22, commercial permit application for Dallas Miriam Temple in Precinct 3.
And this is for the commercial permit for them to begin construction once the plat's finalized.
Motion to approve.
Second.
Got a motion second. All in favor say aye.
Aye.
All opposed? Motion carries. Action number 23, consideration of preliminary plat for the Meadows Development. Daniel?
I was going to suggest, Judge, could we take a 5-minute break before we enter this one? It might take a couple of minutes.
Yeah.
Okay.
Amen.
All right, we'll take a 5-minute break. Good to see you. It's been a while. Good to see you. All right, commissioners, let's go. Where's Harrison? Oh, there he is. Let's get back in session. Yeah, all of it. I said divided by all the counties. Okay, is everybody back? Oh, David's still signing his John Henry. All right. Gary's getting water. All right, we're back in session. 12:55. We're back in session. We didn't really do anything but take a break. So, Daniel, number 23, consideration of preliminary plat for the Meadows development.
All right. This is the Meadows development that's made a whole lot of news lately. I have provided to the Commissioners Court a proposed resolution related to that. The way that I've written the proposed resolution disapproves the preliminary plat application based on a whole bunch of different reasons. And I'm going to go over those. And this is it's about an 8 or 9 page document that goes into all of those reasons with a lot of specificity. That's required under the Chapter 232 that I mentioned earlier. Anytime that there's a plat application that comes in under the current requirements of Chapter 232, the Commissioners Court's required to do very specific things and follow very specific timelines. One of the specific things is that if you're going to disapprove, they took out the word deny, even though everybody uses the word deny. We have to use the word disapprove because that's what the law says. And the law also says that you have to do that within 30 days. We're within that period right now, 26 days into the 30-day period. And you have to send back, you have to adopt a resolution that says what you're going to do, either approve or disapprove. And if you disapprove, you have to send back a list of specific written items. You have to explain why, what the technical problems are with the documentation that's been presented. And then you have to cite to whichever legal provision that you're denying this based upon. And that denial has to be based on Chapter 232 unless there is a separate legal issue. There's not really here, not one that would allow the Commissioners Court to make a decision one way or the other. Obviously, yesterday, the Attorney General sent a letter to the Commissioners Court with 150 plus pages of exhibits. That letter was a short 2-page letter that urged the county to look at the exhibits and take notice of the lawsuit that's been filed and the temporary injunction that was issued by the Collin County District Court that is considering that. As we go through this resolution, you'll see that certain technical elements of what was in the AG's letter are referenced in here, but the underlying basic reasoning for the lawsuit is not. It's not part of Chapter 232, and therefore can't serve as any sort of independent basis for the Commissioners Court to deny or to disapprove the preliminary plat. There are 13 other reasons to disapprove this plat as filed, and we're going to go over those in a little bit of detail. And then as we go through this, just stop me if you have any questions about why any of these are a problem or what the next steps are going to be at the end. And after I get through going over this resolution, if you have any legal questions that are questions of, related to liability or legal construction or anything like that, we can discuss those in executive session. If you have policy questions or discussions to have, those can't be in executive. They have to be obviously in the open. And this is a rule that I know that you're all familiar with. But if you have that document in front of you that I handed out earlier, the title is pretty self-explanatory and goes through what is going on here. My proposed language is to us, and then it'll go into the reasons later on. The key point here is very simple, though. The proposed disapproval is based on technical, regulatory, and legal deficiencies in the application itself. It's not based on race or religion or any of the other things that have caused concern in the community, because those cannot form the basis of any decision that the Commissioners Court makes. The application itself was submitted on February 26th, and so the Commissioners Court has to take action by March 28th in order to meet the 30-day shot clock. Each of the intended or the proposed grounds for a disapproval all are drafted the way that they are drafted in this resolution to stand on their own. And so each one of these reasons that we'll go over could stand on its own as a basis to support the disapproval. And we'll get into why later on. The first category is engineering and plat nonconformance. The county has an outside engineer, Vance Lyles, and he reviewed this plat and the accompanying documentation when it came in. And he issued a review letter on March 17th and identified 8 different specific deficiencies in the preliminary plat. The resolution tracks those directly, first of all up in the whereas section, and then later on in the therefore section. But I'm going to go over those very briefly. Number 1, missing street names. Sheets 2, 4, 6, 7, and 8 have missing street names. The vicinity maps are not to scale on sheets 1, 2, 4, 6, 7, and 8. Even though the regulations require a scale of no more than 1 inch to 1,000 feet. Boundary monuments are not labeled on sheets 2, 4, 6, 7, and 8. Multiple blocks with frontage have up to 72 lots, despite the county's regulation requiring a 12-lot maximum. There was a failure to satisfy the 80-foot minimum lot frontage for lots under 1 acre. The utility easements don't meet the 20-foot minimum width. Multiple Hunt County streets in the plat that fail the 330-foot minimum center line radius. Street approaches that fail the 100-foot minimum tangent requirement. And those details are in the resolution, and we can go over those. And if you'd like to see any of the maps, we can go over those in detail while looking at the maps. But those items were pointed out in our engineer's letter referencing all of the deficiencies in the application itself. The second category is the utility service insufficiency. especially the wastewater will serve letter. Now, I've got a copy here of a couple of letters that were submitted. One was submitted from Dunaway Engineering Group. This is the water will serve letter. That letter was included with the application to show that there was water going to be available to the site, and the other letter, it says Westwood at the top. Westwood is the engineering firm that submitted the application. They also submitted a very short letter that is to the Board of Directors of the Double R Mud Number 2A, and talks about sufficient capacity for sanitary sewer needs. Both of these letters, I believe, are insufficient, technically insufficient to support an approval and require a denial of the plat. First of all, the wastewater letter, which is 2 sentences long, is dated December 23rd, 2025, and signed by the Westwood engineer on behalf of the Double R Mud Number 2A. The resolution says that the letter is legally insufficient on at least 6 separate wastewater grounds, plus a separate water letter ground. First, the resolution states that the Double R Mud 2A is listed as inactive with the TCEQ. The inactive position of that mud in TCEQ records is something that was pointed out and is a major part of the Attorney General's lawsuit. The county is entitled to conclude, because of the inactivity or the inactive position of that mud on the TCEQ's records, that the Double R Mud Number 2A cannot provide the wastewater that it says in this letter that it will provide, and the insufficiency of that letter because of the inability to act of the Double R Mud Number 2A board is one of the independent bases for disapproval of the preliminary plat. On January 23rd, there was a submission of a TCEQ Form 0179 that had been transmitted, at least according to the developers, but that form has not been provided to Hunt County. I checked with the civil attorney for Collin County yesterday. It's also not been provided to them. Collin County provided their letter. They're going down a separate path related to this proposed development, but I asked to see a copy of their documents, and apparently that Form 0179 has not been, at least of the date of their last letter, had also not been given to that county. The resolution that's in front of you also challenges whether the purported board members of the Double R Mud were legally qualified under a specific section of the Water Code, 54.102. It points to the 5 special warranty deeds submitted as proof of qualification and identifies multiple problems. And those are things that the technical aspects of the Attorney General's lawsuit that are referenced in this resolution. Things such as inconsistencies in the date, the wrong grantor, delayed recording, which was more than 4 months after the claimed execution date. The resolution also notes that the Collin County Director of Engineering reviewed those same deeds and independently came to the same conclusion that those deeds did not appear to validly convey the property as claimed. That's important because I know we've all heard the story at this point of the meeting that the mud board had in the middle of a field, and one at a time elected other officers to that board. The 5 officers that are purporting to act as the board for the Double R Mud 2A are the people who are referenced in that section, the people that are required to have property in the mud in order to be able to act on behalf of the mud. The third ground is that the TCEQ opened an inquiry into the qualifications of these directors in January of this year, January 16th. They required a response within 10 days, and as far as the records show that we've seen, there are no response was made to the TCEQ. Fourth, the resolution points to the state's lawsuit and the restraining order, but only in a very limited way. On February 17th, the state filed a suit challenging the validity of the board based on that meeting in the field and the September 12th annexation. And when I say the annexation, it's important to point out that this mud started as a small area. It was 5 acres or so, and was expanded by annexing hundreds of acres around it. That's part of the Attorney General's lawsuit. That doesn't have any bearing directly on the decision about whether or not to approve this plat, but it's important background to understand how the AG's lawsuit is separate from the decision that the Commissioner's Court needs to make today. A few days ago, on March 19th, the Collin County District Court entered a temporary restraining order, which was part of the packet that the Attorney General sent yesterday. And that restrained the purported directors, the 5 people, or the however many there were, directors of the MUD, from exercising any board authority, including entering into any sort of binding obligations and service commitments, like the will serve letter, for lack of a better title, related to sanitary sewer service. If the authority of the board, the MUD board, is actively under challenge and the board is restrained from acting, the county can question whether a service commitment attributed to that entity is legally reliable. This is a utility authority issue and is completely separate from the rest of the claims in the Attorney General's lawsuit. Fifth, the wastewater letter itself is conditional. It says that the MUD, quote, will have sufficient capacity after completion of the district's wastewater treatment plant. The resolution says that that's not enough because the application doesn't show that a wastewater treatment plant has been designed, approved, or constructed. A promise of future service after a future plant is built is not the same as proof of present or legally adequate service. The memo or the resolution also walks through that there allegedly exists a discharge permit with a claimed capacity of 0.9 million gallons a day. However, the county was not provided with any of those documents, any of the documents related to the application or the TCEQ approval of that discharge permit. Sixth, the wastewater document's also defective in form. It's not actually a will serve letter from the utility to the developer or the county. Instead, it's the district engineer writing to the district's own board. And under the subdivision requirements, section 10.02, the county requires a will serve letter from the utility. And under 10.04, the county requires a letter from the wastewater utility accepting the infrastructure. The submitted document doesn't do either one of those things. In blunt terms, the resolution treats it as an internal engineering memorandum, not legally sufficient utility commitment. There's also an independent water service defect, and this relates to the other letter from Dunaway. The application that was filed 26 days ago relies on this letter from Eddie Daniel at Dunaway, and it's addressed to the general manager at Caddo Basin SUD. The resolution says that the water letter is insufficient for two separate reasons. First, like the wastewater letter, it's not a true will serve commitment from the utility to the county. It's an engineer's internal evaluation addressed to its own utility manager. Two, and this is more important, the letter has a 6-month validity period and therefore expired about 7 months before the application was filed. This, by its own terms, on its own face, it would have expired as of August 6th, which was long before the February 26th filing of the application. So by the time the county received the application, the wastewater service support in the letter was already facially invalid. All right, so those are the first two general categories, the elements brought forth by our engineer, and then the problems with the will serve letters. There's a third general category here, which is also referenced in the resolution, which is administrative incompleteness. The resolution says that the application was submitted with the application field blank, the property identification number field was blank, and the date of acceptance field is blank. And those are listed as a complete separate issue. Now, let's talk about for a moment the Attorney General's lawsuit and the statements made to both Collin and Hunt counties. From a legal perspective, the county cannot rely on anything in the lawsuit or the TRO or the Attorney General's letter when it's making its decision under Chapter 232 and decisions based on our subdivision regulation. The law just doesn't allow it. It doesn't matter how much dislike there is for the project or the developer or any of the groups involved. The law is very clear that any decision has to be made specifically on the things that the legislature has given the county in the way of authority to approve or to disapprove. The Attorney General's lawsuit makes claims that have absolutely nothing to do with that, including securities fraud allegations. And so there are a couple of different sections of the resolution itself, both at the beginning, whereas section that goes over the findings, basically, or not the findings, but the reasoning for the Commissioner's Court action. In fact, on the third page, right in the middle, there's a section that begins, whereas as the subground B4, and then goes through the lawsuit itself. And it cites to the lawsuit, but just for the application of those very specific technical issues. The next to last whereas statement, which is at the very bottom of the next page, it begins with, whereas the Commissioner's Court received and reviewed the March 23rd, 2026 letter. That also goes into exactly what the court's review and the county employees' reviews have been related to that suit. And those things are only referenced and only had a bearing on the decision to the extent that they were supportive or related to the technical grounds that I've already gone over. At the very end of this document, I think it's section 10, on the very last page, there's a section called Attorney General Records. And this goes over what the county received yesterday, and again, specifically says that those documents from the Attorney General are neither incorporated by reference or adopted as part of this decision-making process. Again, because the Attorney General's basis for the lawsuit and the TRO has nothing to do with the approval or disapproval of this, except as to how it relates to the alleged inability of the MUD board to take any action because of open meetings illegality. and then the related TCEQ positions and actions. And when I say position, I mean the position regarding the inactivity of the or the lack of an active MUD. That distinction matters in court because if the Attorney General's letter was read to imply that the county should just not make a decision on this because of the pending action, that is not a position that's supported by Chapter 232 and would result in a likely lawsuit and a potential loss for the county and the county's taxpayers. As I said at the beginning and several times through this, none of the things that are in this proposed disapproval resolution are based on religion or national origin or on the unrelated litigation in Collin County. The county's duty here when reviewing this is to strictly apply the requirements of the subdivision regulations and Chapter 232. Under those standards, anything that is in an application that doesn't conform must be disapproved. If there's legal questions about any of the items that are in here, I can answer those as long as they don't relate to liability or technical code construction that might lend itself to liability. But if there's general questions about the reasoning for my office proposing this disapproval, I can answer those general questions now.
I've got a question, I guess. Say we disapprove this today, and what time period do they have to go cure it all, or do they have the opportunity to go to cure it, or where? How does that all flow? What is it? What's the end game if we? Either way, whether we approve or disapprove it, what's the end game of it?
Yes, to the extent that any of these technical violations are curable, and I think almost all of them are easily curable, like the street names and the widths of the street, those can be cured and there can be a resubmittal. There are a lot of different timeframes involved. The county, based on whatever decision you make today, the county is required to send within the next few days a written set of reasoning pointing out the legal and technical deficiencies. That puts them in a position where they can either stick with the current process and file supplemental materials within a certain number of days, which is a short time period, or they can start the process over again, which starts the 30-day shot clock over again. That's outside of the county's control and would be up to the developer on which direction they choose if this plat was disapproved.
So the Attorney General sued the developer. Collin County, have they sued them?
No.
They have not. They just denied, they didn't deny the plat. They just said it's not complete, I think is what they did.
That's correct. They said it wasn't administratively complete, and we don't have that option here based on timelines.
So if the state wins or Collin County ends up in a suit with it, do we follow along with that, or they still can come develop the land in Hunt County that nothing we can do about it, or how's that going to work?
Well, it depends on how they do it. The attorney, I mean, there's nothing that is going to require Hunt County to participate in a lawsuit unless the county is made a party by a different party. So if the developer sues the county, then the county would necessarily have to participate in that lawsuit. But that would likely not be the same lawsuit as the one that's pending right now.
So we wouldn't get drug into with the current ones?
It's very unlikely that we would, because those are claims that can only be brought by the Attorney General, not by local counties.
Okay.
But it also, what impact it would have on the owners and developers' ability to continue to develop out there is up in the air, because it kind of depends on what the resolution of the open questions is. One of the questions that the AG is asking the court to make a decision on is whether or not the MUD is legally viable in its current position, with the current directors that were, allegedly put into place in September. All of that is on a kind of a separate plane from the development itself. It's only really interrelated in that the will serve letter on the sanitary sewer is for a wastewater treatment plant that would be operated by the MUD itself. And so that's really the only connection between these two, because the owners of that land can come back and fix all of these issues and apply in a different way than they already have. They are unlikely to do that given the current state rules and the regulatory scheme, because that removes their ability to tax and spend, basically, by issuing bonds and then using that bond money to build the horizontal infrastructure to support the neighborhood. The way that these MUDs work generally is to issue bonds, in this case close to $1 billion most likely, in any case hundreds of millions of dollars, to build streets and all of the other horizontal infrastructure like water, sewer, and everything else. And then the people who buy those lots that are within the MUD then pay a special tax on top of their property taxes called an assessment. And that assessment goes back to the developers to pay the bond, the initial borrow, down. In some cases, in some neighborhoods, that can lead to costs that far exceed what the property taxes are, especially when the property taxes are on just an empty piece of property that could be used for a house later on. Those taxes are going to be relatively low, but the assessment's going to be based on a percentage of the access to those utilities and other horizontal infrastructure that it receives. And so the ability of this group to build that development is going to be hampered in two different ways by if the Attorney General is successful in attacking the MUD's existence. Number one is that they wouldn't be able to issue the bonds and therefore, pay for the expensive upfront costs of the development itself. It also hampers their ability to do the planned wastewater site in the southeast corner of the development itself, because the application, my understanding is the application is in front of the TCEQ through the MUD. But if the MUD can't act because the Attorney General is successful in removing those people from office, or by showing that they're illegally in office through a quo warranto action, which is when you remove somebody that purports to be in a position, then their ability to move forward as they're currently attempting to move forward would be severely curtailed.
So they had a reason for getting that other MUD going, and I remember hearing it, but what was the reasoning? Because they already had the approval of a sewer treatment plant or something. Was that what the reason was?
That part is not super clear to me. Looking back at all the records and the timeline, I've read multiple different things about that, but it's not super clear. The behind-the-scenes reasoning and what the relationship is between all the parties involved in this development compared to the adjacent developments.
So the Epic land was not in a MUD. They never created a MUD, but the DR4, whatever name of it is, Double R Mud.
Double R Mud.
They can enlarge, they're going to enlarge that in Epic. Is that what they're trying to do?
Yes. So it started as a small piece of a mud. That's why it has that number, Double R Mud number 2A, as opposed to just the Double R Mud. Because this was a piece of an existing mud, and by administrative action, it was shaved off effectively and then expanded through action of the board to annex all of the other acreage around it, bounded on the sides by, on the Hunt County side by Brushy Creek, and then 3 roads partially in Hunt County, but mostly in Collin County.
So a mud can annex more land in, but a city can't.
Yeah, that's correct.
Oh, that's great. That's
I mean,
great law.
cities can, as long as there's a request by the landowner to do it. But they can't administratively, and MUDs can only do it with, if they follow very specific statutory requirements. In this case, there effectively was a landowner request because of the way that they attempted to set this up. And what the Attorney General is going after them on is a technical set of technical violations of the Open Meetings Act, in addition to all of the religion-based issues that are in the lawsuit.
So Daniel, and I know there's a lot at play in this conversation, and I always oversimplify things. So I'm going to ask a question. You can tell me I'm oversimplifying. To me, I look at it, and so we have engineering and regulatory deficiencies, a couple of will serve issues, and we also have the administrative shortcomings, of which any one of those, not only would we, but I believe we have disapproved plats in the past for, right?
That's correct.
And so this is to me, this much deficiency is pretty normal routine for us.
This is a routine disapproval for those issues. And it really, I mean, other than that connection where the Attorney General is suing based on open meetings and quo warranto, the connection to the Double R Mud 2A's sewer treatment plant, the thing that's before you right now has literally nothing to do with the plans for the facility. In fact, it can't. State and federal law make it very clear that no decision of a commissioner's court that's considering this sort of thing can even consider those issues. All of these other things are independent of those separate sets of reasoning.
And substantive on their own to what we've historically done.
That's correct.
Yeah. Okay.
Anybody else? So decision time?
Yes. Or if there's any public comment, you can take that as well. There is no public hearing on this. This is a decision of the court, and when the time comes, you can move to accept the resolution as written, and it would effectively work as a resolution denying. There's also I will point out one very last thing on the very last substantive paragraph, section 11 on the last page. I will say that when they rewrote Chapter 232, they did say, the legislature said specifically how a grant has to happen, which is by order of the court. And an order is obviously different from a resolution. It doesn't say how the rest of these actions are meant to be, are required to go through court. And so this section points that out and includes a finding that to the extent that later in court there's an attempt to construe that statutory requirement for an approval to be an order, and to say that this is insufficient because it's a resolution instead of an order, then the court is expressly finding that it is adopting it as written with an attempt, in an attempt to comply with the specific wording of Chapter 232, and that the way that you're finding and the way that this is written can constitute an order of the court disapproving the application. I included that section based on other experience that I've had dealing with Chapter 232 and court cases. There are very few court cases currently pending because this is such a brand-new statute. In fact, there's only 2 others, and they're for a neighboring county. But it's a neighboring county that is in litigation with almost the exact same parties. And they're nothing if not technical. And so part of the reason this is as long as it is to attempt to capture all of the technical requirements of Chapter 232, which is the reason some of this seems repetitive. But at this point, you can hear any comments from the public on this issue, or if there are none of those, then you can move to approve or not approve, or if you want to make any changes, we can certainly do that as well.
Does the court have any changes that they'd like to do?
No.
Court ready to vote, or we want to hear from?
Should hear from the public.
We'll have to have
From
a
the
public
public.
hearing on it?
Nope.
If the public's got anything, we need to let them speak.
Yep.
Well, I think we can give a straw poll at least. That I know I'm against. I'm going to be for this. So.
Yep.
You got one that wants to speak?
Come ahead.
I will agree, Scott Finney, again with what your attorney is saying in the requirements for the subdivision. In order for the subdivision to get approved at a TCEQ level, they do have to have a viable way to prove through a design on a sewer plant that they can handle the wastewater for what they're calling for. I did see the Dunaway letter and the will serve. There is an absence of, yes, we will provide X amount of water and how it will be done. That's missing as well. So I agree with what he's saying if they find that any help, especially from somebody that builds them and does it.
As long as TCEQ actually pays attention to that and doesn't just rubber stamp it like
To
everything else.
give you a little insight on the TCEQ process, everybody thinks, wow, it's a big board. It's 3 people.
Yeah.
So what they're going to do is they'll go through this drawn-out process, and TCEQ will assign 3 or 4 people arbitrarily. Nobody knows who.
Well, what they've said in public at meetings we've been at, have said, if they meet all our rules, we have to approve it.
Oh, I'm not disagreeing with you at all.
So it's
there.
just, I mean, why are you going through all of this?
Throughout all this entire process, it has blown me
Ridiculous.
away that the county was not given more oversight. But at the same token, throughout the history of development, we had people that were doing it legitimately. We all hate developers, right? So I'm saying we weren't circumventing what COG specs were.
Yeah.
This is just different.
It's way different.
Thank y'all. I appreciate your time.
You bet. Anybody else? If not, I'll entertain a motion to approve the disapproving of the preliminary plat, application number 26-0226, called the Meadows.
Make a motion to, there you go, second. We're all in motion and seconding.
All right, got a motion second, no other discussion. All in favor, say aye.
Aye.
All opposed? Motion carries. All right, Daniel, I know we probably had some executive session stuff. It's late. Is it something we can do tomorrow, or do we have to do something today?
Not on the agenda for tomorrow.
Oh, okay.
But if you can read the first statement.
Can I have one of these?
And then on the second half,
All of them?
Do I have to read those? All of that?
She said 992.
Okay, at this time, we're going to go under, we'll recess into executive session pursuant to Texas Government Code Section 551.071, 1-2, to consult with the county civil attorney on Castle Rock road repair Attorney General lawsuit against Double R Municipal Utility District 2A of Hunt and Collin Counties et al., Lake Tawakoni zoning regulations, HR attorney. Is that all of them, Daniel? I think I got them all. Yeah. Okay, we're at
Trail.
1:38. We're moving into executive session. Thank you.
He should have stayed. He
All right.
had a cookie.
We back up?
I don't know.
All right, it's 12:30, excuse me, it's 2:32, my goodness. Where'd lunch go? It's 2:32, we're back in regular session. Any other business before the court today? Being none, I entertain a motion to adjourn.
So moved. Second.
Got a motion second, all in favor say aye.
Aye.
All opposed? Motion carries. We're adjourned at 2:32. That may be a record. Not a good